question is really how far in these circumstances the media defendants have to go to investigate all of that.
Well, your Lordship will be familiar with the matter of bogoshi, and you know that the high watermark of the bogoshi defence, in order for a media defendant to escape liability under defamation, is they have to meet the threshold of all circumstances, of all facts known at that particular time.
Yeah.
So with respect, my Lord, in circumstances where not only does the subject of the adverse reporting give a factual account of if you had to evaluate it on a like-for-like basis, destroys the version that is put up to him in order to comment on. When the subject matter of that adverse reporting goes on to give further details and invites the reporter to do something like consult the CCTV footage of the premises where the alleged rape took place, and in the absence of objective evidence as to why the media published when they did, rather than delay themselves and doing the kind of fact-checking that bogoshi speaks about, because in order for it to be reasonable, you must examine all the facts and circumstances known at the time of publication.
Well, reasonable publication only arises if the statement was false.
Correct.
It wasn't false.
Well,
the statement was there has been this complaint, and the subject of the complaint denies it. We contacted the police for comment. They didn't get back to us before we published. All of that on the respondent's version seems to me to be true. And if any of it was false, if they did, for example, say that the applicant committed rape, then we might be in the realm of reasonable publication, because the question would be, could you reasonably make that allegation even though it turned out not to be true?
correct.
So isn't this really all about publication?
No, my Lord, with the greatest of respect, I'm not sure we can leap immediately to that because of the way in which our learned friends plead their defences.
Yeah.
They plead them as being capable of being pleaded altogether, but as your Lordship has foreshadowed to me...
Mr. Keranos, to be fair to him, makes clear in his heads of argument that the proper structuring of the defences...
I take the point no further then.
Yeah, the proper structuring of the defences is you look at truth and public benefit, and you don't really get to reasonable publication if everybody accepts that the fact of the complaint is true.
Yes, but I'll develop that analysis when I come to analysing the articles, if I may.
But before you move on, I just want to get one thing clear.
Yes.
What was reported? What was the basis of the report? Can I infer from the papers that the statement of the complainant itself never fell into the possession of the respondent? Can I infer?
I don't think you can, my Lord, with the greatest of respect.
Or do we do know?
No, I think we do know. If your Lordship will turn up 01-7...
01-7.
Yes. This is an annexure to the notice of motion. It is the first article to which my client refers as the second impugned statement. If your Lordship looks under the, towards the bottom of the page above the file address, it says in capital letters, according. And then it goes on to say...
Sorry, 01-8.
01-7, my Lord, one page back, with respect. It should have NOM2 in the top right-hand corner.
You've got to read that with the respondent's version. The respondent's version, as far as I can see in the answer here, and please tell me if I missed it, is that somebody rang them up from within the SAPS and told them what was in the statement.
They were leaked certain details regarding the woman's statement.
Doesn't they have the statement, does it?
Not necessarily, no.
But if one looks at the conspectus of all of the facts, that's why I'm saying, can I draw the conclusion that actually the respondents never had the statement? What they had was an informant within the police who told them what was in the statement.
Well, with respect, my Lord, then there are two contradictory versions put up by the respondent insofar as how they construct the article.
So where do they?
Because look, if you look at the bottom of the page that I just referred your Lordship to, 01-7, it says, according to the woman's police statement, Ndlozi allegedly did whatever.
Yeah.
And so what I'm saying.
The difficulty is that I have to know whether they had the statement or not, don't
Well, I mean, that's, your lordship will know on the papers there's an issue about the Rule 3512 and whether or not it's being persisted with and whether
I thought that was
the
whole
request was
reason
good.
I thought that was the whole reason you issued the Rule 3512, to find out if they had.
Yes, exactly, and then it wasn't taken any further.
Well, presumably they didn't give it to you because they don't have it.
I will take an instruction on that.
They
I can't.
don't say in their answering
I can't remember if that's the answer that was given.
And they don't say in their answering affidavit they have.
No, my lord.
See, the reason why, let me put my cards on the table. The reason why I'm asking these questions is the first statement you complain is essentially a billboard.
Yes.
That appears shorn of any context that might be supplied by the article.
Yes.
The applicant says he saw it driving up Jan Smuts Avenue.
Yes.
Somewhere around Dunkeld.
That's right.
It then appears.
And that it appeared online.
Then appears online. I think in context I can accept the day before any article was
Correct.
available.
Correct.
To, contextualize.
Correct.
And a lot is made of the fact that it's in quotation.
Correct.
But the words Mbuyiseni Ndlozi raped me in quotation marks implies one of two things. Either that the respondents have actually spoken to the complainant. That doesn't seem to be their version, doesn't seem to happen.
Correct.
Or that they had the statement.
Correct.
And
Or that they were told, as your lordship posited, they were told by some third party what the content of the statement was.
does that follow? Would the reasonable reader looking at this billboard conclude that one of the possibilities was that somebody in the police had told the Daily Sun
No.
that Mbuyiseni had raped them?
No.
I mean, the statement is a quotation of a first-person allegation made by the complainant, a quotation from it, which implies, doesn't belong to the reasonable reader, either that the Sun had actually spoken to the complainant or they'd seen the statement. Doesn't that make a difference to how one, first of all, interprets the truth of this particular statement, finds to what extent it's true, the sense in which it was conveyed, and secondly, whether this particular statement was in the public interest?
Well, can I start off just by analysing this? Because your lordship makes a number of qualifications which ipso facto obviously don't appear in the statement as complained of itself. Now, your lordship knows, and our learned friends have quoted this at some length in their heads of argument, that a headline cannot be isolated absent the article. But as your lordship has already acknowledged for me, this headline appeared in and of itself without an article accompanying it.
Precisely my difficulty.
To give it any context. So can we just, and I apologize to my lord, I intended on addressing this a different way, but I'm going to do it now because your lordship has it in front of you.
I should be apologising to you, Mr. President, for leading you around the papers, but yeah, go ahead.
It's the benefit of being elevated to the bench, my lord. But the point is this.
Yeah.
In the first instance, you know that the analysis which our learned friends would perhaps rely upon to add context to the statement does not apply, because on the facts, this statement applied on its own without any further context. That's why we say, with the greatest of respect, it is a presentation of a statement of fact. It's a presentation of a statement of fact because regardless of where the origin of the quotation comes from, looking simply at the words themselves, one is not left with any countervailing impression that Ndlozi could have done anything else other than what is alleged in the statement itself.
They say that the inverted commas means that it's reported speech, and so they're reporting what someone else said.
Well, under the repetition rule, with the greatest of respect, they would nonetheless be guilty of defamation, because our jurisprudence in this country supports that, because the logical conclusion of that kind of defense is that a media house would always be able to escape being held accountable for defamatory statements if all they had to prove was that it was said by someone else. And the point...
No, if they, that's why I think public interest is at the centre of this case. Is it in the public interest to print a billboard from quoting a very serious allegation against someone
Yes.
from a third party that you haven't spoken to in a sworn statement you haven't seen.
I would suggest that that militates against it being in the public interest because that's not doing the basic fact-checking
Isn't that
analysis.
the core question on the first statement?
Absolutely, sir.
Yeah.
The other point, and can I just point this out to you, my lord, is that the Daily Sun itself is not alert to the complaint, because if your lordship looks at Annexure N0M3,
Yeah.
and now I know there's some confusion about which article it is that we complain of. I'm at 01-15. Your lordship will see that I'm focusing on the article that appears towards the bottom of the page.
Yeah.
Look at the difference in wording. Ndlozi is not a rape suspect, cops. Now, the simple analysis we would say is compare and contrast what they say in that second article headline that I've just read out to you, compared with the first one. The point to be made about the first statement is that there's no qualification of the content of that statement at all in the first statement, and the first statement presents as matter of fact that Mr. Ndlozi raped someone.
Yeah, but here you do have to read the headlines together with the article.
Oh,
because the articles appear
correct.
below.
Correct.
The article at the side has almost nothing to do with the applicant. It's the Sun trying to hit back at the police for saying what they thought was something misleading about the way their journalists have conducted themselves.
I'll come there in a moment. And indeed your lordship is correct. The substantive analysis of the two articles are different. But what I'm drawing attention to is the way in which the qualification appears in the latter one and does not appear in the first one. And that's why we say it constitutes defamatory material. And no public interest...
We know we can stand by our story. We only know that Dr. Ndlozi has been exonerated because the cops have told us.
Sorry, I think we're speaking past each other, my lord. I'm referring to the first statement again, not the we stand by our story.
Which one are you talking about?
I'm talking about the statement that, yes, I'm just drawing your lordship's
right,
attention
sorry.
to the distinction in the way in which the reporting occurred.
Oh, I see.
Yes,
Sorry,
that's the point that I'm making, is that absent the qualification, which then might have been defeating of my client's complaint about this particular poster, this is presented as a statement of fact. Because it leaves, in the words of Chief Justice Steyn, and I can't believe I'm going to quote Chief Justice Steyn in the Utah case, but Chief Justice Steyn in the Utah case makes it abundantly clear. The threshold is, does the word leave the reasonable reader with any contrary conclusion to reach?
What is the fact being presented?
That Mr. Ndlozi raped someone.
And you're saying the inverted commas make no difference?
Make no difference whatsoever. Because whether that is someone saying that Mr. Ndlozi raped me, and then it is repeated by the Daily Sun, which attracts liability for them in the first place, doesn't take their argument very much further, is the first response. And the second one is that...
And they could never repeat any complaint with anyone?
No, that with respect, my lord, that puts to me an either-or proposition which I'm not endorsing at all. The point is they could have qualified this very same statement. They could have put in a heading, a subheading above this and said allegation, Mbuyiseni Ndlozi raped me.
Let's not dance around the point. Their argument, as I understand it, and Mr. Keranos will correct me if I'm wrong, is that the inverted commas do exactly that.
And I'm saying that that's neither here nor there.
Now I know what the ambit of the dispute is.
Right.
Yeah, thank you.
So, my lord, you've got my submissions on
I do.
the first one. Can we then turn to the second
There
one?
is the secondary point of even if they're right, and the inverted commas do provide that qualification, then isn't it material to this case what those words were a quote from?
Or who they were from, or how they were acquired, or how they came about. My lord, with the greatest of respect, the court puts the question pertinently, because Dr. Ndlozi's case has never been that they can't report anything, because that would reach too far into suppressing media freedom rights. It's rather about, if you're going to publish something like that about me, qualify it appropriately so the reasonable reader who drives past it on in Dunkeld is not left with the single conclusion that I raped somebody, but that it is an allegation, it is open to debate, it is being contested, or anything of the kind.
Well, to be fair to the respondents, their point goes a little bit further than that. Even if the inverted commas weren't there, it's obviously reported speech.
But that's exactly.
I know what your answer to that is, but I'm just trying to make sure that you get an opportunity to give it.
No, I mean, it doesn't. With respect, it doesn't matter. It doesn't help them. In fact, it makes it worse, because what they do then in the statement is they post a third party's version as chapter and verse being correct, without any qualification at all. So even if it is direct speech, which may still be actionable in separate defamation proceedings, it's their responsibilities in respect of what they publish. And the simple point is that they never discharged any of those responsibilities in respect of at least the first statement.
Yeah, I have your points there.
Can I go to the second statement then,
Yeah.
NAM2? Because this is, I think, where your Lordship and I were starting to enter into the realm of reasonable publication and so on.
Yeah.
The first one is that we would say that the headline bears a direct correlation to what was reproduced at NOM1. So I would say that that headline is defamatory on the same arguments that I've just made to your Lordship. Now, here are a couple of other salient features.
But only if I shear it from the context that follows.
No. I'm not asking your Lordship to do that. What I'm saying is that when one then does the fuller analysis, having regard to everything else that is in the statement, that throws into sharper relief how defamatory the content is. What I'm saying is right from the get-go, the headline, the defamation is committed, and the way in which the article is presented sustains the defamation throughout. And I'll demonstrate it to your Lordship as follows. Now, firstly, your Lordship will, we've already touched on this, but at the bottom of page 01-7, there's the statement that is made according to the Women's Police Statement. Mbuyiseni Ndlozi allegedly, and then it goes over the page. Now, what we would point out in the entirety of this article is that the reasonable reader could not be forgiven for thinking that this was based on the conduct of an interview, because at no particular point do the respondents make it explicitly clear that this content that they're reproducing here was as they're lifting directly from a complainant's victim statement, and that they took no further steps in respect of fact-checking or in other ways interrogating what is put in here. Now, I know I'll point out what's against me. In certain paragraphs, for example, on page 01-8, you will see, for example, the quotation at paragraph 1, 2, 3, 4, 5, fifth unnumbered paragraph, starting, the complainant alleged she was invited, okay, in direct reported speech. And even though it says read the statement, what your Lordship will have attention to the fact is that right at the very beginning, it's right at the very end, I apologize, it says the victim was unavailable for comment. So in other words, the entire narrative is presented here based on the one-sided version of the victim in her victim's statement. Now, my Lord, you would understand, and I think everyone would understand, that when a victim goes to a police station in order to report a crime, they must be given license to put whatever they think appropriate, relevant, and material before the police and ultimately the prosecution if a decision regarding prosecution is going to be made. When the victim is making the victim statement, they don't have to engage in fact-checking. They don't have to engage in any of the duties that media respondents have to. They are entitled, as of right, to put their version before the police. Now, the difficulty that we have in this particular matter, as highlighted by the fact that the Daily Sun says the victim was unavailable for comment, is what do we know as a matter of fact? As a matter of fact, there were engagements between my clients and the Daily Sun. My client had given a version to them My client not only gave a version to them, but made an open tender invitation and said, go check the CCTV footage of the premises. It will corroborate everything that I've said. So in other words, when the Daily Sun came to publish the victim statement, as though it appears to have been conducted by an interview, which it wasn't, but when it reproduces the media statement and doesn't get the victim's complaint, what they do is they don't put new information in front of that very same victim who might, in light of the new evidence that were uniquely in their knowledge, not have stood by her victim statement.
They have to do that. Can't they, isn't it enough that they publish the contents of the statement and they ask the applicant for his version, they place those two versions side by side, the minute they knew that the police had ruled the applicant out, they said so. Why should the media have to go any further? Assuming that this is a matter of public interest.
Of course, of course.
Yeah.
May I address that in two ways?
Yeah.
The first way is that they were reproducing verbatim the victim statement. That information immediately after it was given, and if I'm not mistaken, that media statement was given on or about the 9th of April. The alleged incident happened on the 9th of April, and then the statement was made not too long thereafter.
Yeah.
But the point is that the victim in the victim statement knew what they knew at that particular moment in time. When the Daily Sun comes to publish this article, an entirely new set of facts are put in front of them. Why they have to go one step further is because, in essence, what they're relying on in this particular article is they're relying on, and I'm going to use this word guardedly, stale information communicated at the time that the victim statement was made, which is contradicted by the subject of the report, who says, go do X, Y, and Z, and you'll see that whatever is said against me is not correct. Now, the difficulty for our learned friend's client is that when the article says the victim was unavailable for comment, that's not the victim commenting on the original victim statement, because we know what the version of the victim statement is. It's the victim being given an opportunity to have the new information placed in front of her, because victims change their minds about who the identity is, or what may have happened, or what may have not happened. And I'm not speculating about the bona fides of the victim at all in this particular matter. I will stand by the fact, and so does my client, that the victim statement is the victim statement. Rather, it's about the duty before publication in circumstances where new facts come to light. And what we would say to your lordship, that as the media, they are the bearer of those particular responsibilities, because not only does the press code tell you that they have to do such things, we also know that from bogoshi, at the time of publication is when they have to engage with all relevant facts and circumstances.
Wasn't bogoshi about a situation where they didn't ask the subject of a report for comment at all?
No, correct, and we're not in that territory, but the reasonableness threshold in bogoshi is no less watered down. It sets out what is appropriate on the facts and circumstances known at the time.
And bogoshi was also about a report that turned out not to be true, whereas the fact of the statement is true.
Yes, but with respect, that's...
The complainant statement.
Yes, indeed.
Yeah.
So that's...
It just seems to me that your submissions are very close to the line between bad reporting and defamation, or at least bad reporting and unlawful defamation. Do you have any authority that can confirm to me which side of the line you're on? It would have been better, of course, had the journalist checked the CCTV footage.
Absolutely.
It would have been better, of course, had they waited
Absolutely.
for the police to finish dragging their feet.
Absolutely.
From the statement. All of that would have been better. But would it have, was that just a poor choice on their part, or did it make the report that came out defamatory? That's the line that has to be drawn in this case. Put it another way, had they waited for all of that information, had they waited for the police to exclude the applicant, and had they checked the CCTV footage, and then published a report that this complaint had been made, and set out all the facts that suggest that the complaint was mistaken identity. Would that be defamation?
No, because the reasonableness of the report in those circumstances would speak to the unlawfulness and would be an answer to the unlawfulness of the publication and the conduct being complained of. But
you're using the criterion of reasonable publication outside its proper bounds, it seems to me. Reasonable publication is about untrue statements. This is about true statements, unless I've missed something in the case.
And your Lordship is entirely correct, but remember, what we are saying is that in circumstances where there are two materially contradictory versions, there is no claim to truth in either circumstance, because that would necessarily presuppose the reporter making a value judgment on who is to be believed and not to be believed. And we're not in that territory.
This is where the parties are speaking past each other.
Yeah.
The respondents say the truth that they have to defend is the fact of the complaint. You're saying that merely repeating the content of the complaint is to defame the applicant by calling him a rapist. I have to say that then we're in the territory of saying, well, when can the media report a complaint that's been made to the police? Because every time they report a complaint that's been made to the police, they're repeating the content of the complaint. But then they can never do it.
No, but that's
They'd
not.
always be defaming the.
No, and that's not the position with respect that we said.
Yeah.
We say that the court should take on these particular facts.
Well, the prima facie, the position seems to me to be the fact that the complaint was made is true. That is.
The content of the complaint, however, if I may interrupt your Lordship,
but
is an open question.
Well, let's not go there. The fact of the complaint that was reported, there was this complaint made. This is what the subject of the complaint says about it. All of that context, that story, was true. They say that that's the truth, and the truth of public benefit defence. They say that reasonable publication therefore doesn't apply. They don't have to think about whether they were reasonable to publish. And the only question that arises is whether the report of that true set of events, or the true report of that set of events, was in the public interest. You seem to be saying, well, no, somehow these reports all impute the description rapist to the applicant. And I'm not there. I don't see that. Because if merely reporting a complaint automatically imputed or implied the truth of the content of that complaint, then I'd be shutting down criminal justice reporting in this country forever. At least until the appeal court overturns.
Indeed. I think that the analysis does not hold that your Lordship posited to me in respect of the poster billboard. I think the poster billboard is on different footing because that's shorn of any content attached to it, and that is defamation in and of itself.
That's why I raised that, because the difficulty with the poster billboard is the truth being conveyed by that poster billboard, I think we know, isn't true. Because the poster billboard says, or gives the very strong impression, that someone has gone to the Sun and said the applicant raped me. That didn't happen. Or it gives the impression that the Sun had in its hands a police complaint statement, which I'm still waiting for a definitive answer on this, but I think on papers they plainly didn't have. And there we're in the realm possibly of reasonable publication. I take your point there. And then the question becomes, is it reasonable to print those words on that billboard in those circumstances, whether online or attached to a light post?
And absent qualification.
Yeah, well, with whatever qualification could be read into the inverted commas, which prima facie is not much.
Correct.
Yeah.
But I accept the difficulty that arises in respect of Article 2 there.
Yeah, Articles 2 and 3. That doesn't mean you're out on those articles.
Indeed.
What it means is that the inquiry is whether or not it's in the public interest to publish these allegations in this way about this person in these circumstances. And the cases all make clear it's an entirely factual
Indeed.
inquiry.
Indeed.
I think the statements you complain about can be separated.
Indeed.
In other words.
Indeed.
And that's I suppose that's, in a very large nutshell, the prima facie view I'm putting to.
And I think I accept, I think I'm with your lordship in respect of statement 1, and I accept the difficulties in respect of statements 2 and 3. Can I go to statement 3 and then come back to statement 2?
Yes, please do.
Because and I heard your lordship's remark earlier regarding that ostensibly it has nothing to do with the applicant.
Well, it has something to do with it. The applicant isn't the target of the first story. There was a great deal of ire, it seems, from the Daily Sun's editorial staff, whether justified or not, about what the police had
About what the police did or didn't do. The only point I would make then in respect of that particular statement is that at the time when further facts were known to the Daily Sun, as is reflected in the second article appearing on the same page, where the cops say that my client is not a suspect in the complaint, that the fact that the Daily Sun goes as far to exonerate itself of any potential wrongdoing in the trenchant manner that it has is directly the aggravating factors that the Supreme Court of Appeal in the Manuel case have held further liability in respect of, because in effect it's speaking out of both sides of your mouth. On one hand you say, I know what the true facts are, but I was completely correct in doing what I was doing. And the SCA made short shrift of that. I know, because I happen to be the counsel in that matter, where the SCA gave us a very quick but polite hearing that we could do so. And what the SCA did in that case is it says, where a party in defamation proceedings digs its heels in a way that we say the Daily Sun has in respect of the third statement, is further evidence of its mala fides, actually, rather than a bona fide explanation. Your lordship will know on the papers there's a...
On the headline, we stand by our story.
Exactly.
There's the possibility of that. But
Exactly.
if you read the headline with the content of that article, they're really saying, we stand by our decision to publish this article without immediate comment from the police, because we asked them 5 times and they just never got back to it. And now they've come out with a story saying that we didn't actually ask them, but we did. Isn't that the gist of the story? That's why I say, I don't say it's got nothing to do with the applicant. The applicant, at best for you, is a casualty in another fight.
Correct. But
Yeah.
we would say that that's not irrelevant in the context of determining then the overall sting of the defamatory statements that are made in quick succession over 3 days.
I can understand, even on reading the whole article, why the applicant, after the few days he no doubt had, wouldn't be particularly happy with seeing that headline and that content.
Absolutely so.
But by the same token, the Sun getting into a fight with the police about whether or not they should have published doesn't seem to me to be defamatory.
Your lordship's heard my point about that being an aggravating factor in the context of what the SCA said in Manuel. But can I also just point out this? Your lordship will know that there's a perhaps bold claim made by my client about animus in Uriandi, and whether or not the conduct of the media defendants in these circumstances actually is in that territory rather than in this. We would say that if your lordship bears the attitude taken regarding the journalistic conduct in question, as evidenced in the third statement, coupled with statements that what can be found in the WhatsApp chat, for example, at 01-114.
01-114.
Correct.
Let me just get that.
I don't know if anyone is turning it up with case lines. I don't know if your lordship is
I've
following
got
on
it.
case
I've
lines.
got it. the applicant's
The applicant's
message to.
it's how I read it, and I know my learned friends will correct me if I'm mistaken, but how I read it is as follows, is that if your lordship turns back 2 pages to 01-112,
Yeah.
it's the original message from the journalist, and then where it says questions about a third the way down of the page, or halfway down of the page, the statement appearing with the dash is the question, the dash next to it is the question, and then the response is the one with the colon.
Yeah.
So how one reads this is that the colon text is my client in response, and the rest is the original message of the journalist. And how I read it, and again I will speak subject to correction, is that my client is replying line by line on a message that he had been sent at a previous time.
Yeah.
And that's why he's replying line by line. But if your lordship then goes to 01-114,
Yeah.
your lordship sees our learned friend's client says the following: the article will be published in our edition of Monday, April 12, 2021. We would appreciate if your responses can reach us today by the latest 5 p.m. So the predetermination there that the article was going to be published, come hell or high water, and it would be nice, your answers would be nice to have, rather than necessary to the journalistic inquiry, we says speaks to the aggravating factors which is contained in the headline, "We stand by our story." Either it demonstrates the overall aggravating conduct in respect of the defamation, or it speaks to animus inuriandi. Indeed, if your lordship goes to Annexure AB1, which is in our learned friend's affidavit,
What's the case?
04-48,
4H.
your lordship sees that a similar statement is made at the bottom of that WhatsApp message. The story will be published tomorrow. We would appreciate if your response can reach us by 5, and then turn over the page, 04-49. I mean, this is an extraordinary interchange between Makubele from the SAPS and the journalist, because what the journalist says. He says, what the SAPS man says, call Peters. I'm about halfway down the page, on the left-hand side.
Yes, I'm there.
Then he says, no, Botti, you said I should send questions to you, I asked nicely. And then look at this, it's an extraordinary thing to say. It's your name that's going to appear in the story, so talk to her. So where the journalist is told, go and contact the appropriate person who will be able to answer, the response to the person who's giving that statement is, no, I'm not going to go talk to whomever the right person might be. I'm going to name and shame you with effect.
It's an unhappy exchange.
No, absolutely so, but that speaks to the point that I'm making. And it's not just that it's in a WhatsApp message that we can turn a blind eye to. Look what is said in the answering affidavit with respect. Under oath, our learned friends say this. If your lordship will bear with me, I'll just call up the relevant page. Sorry, my learned friend corrects me. It's not him that says anything under oath, it was his client, obviously.
Mr. Karen asked me very careful not to say anything.
Indeed.
Well, yes, my lord, he did say our learned friend, so
Yes.
which worried me a little.
If your lordship will bear with me. I'm reading from 04-36. 36. The relevant paragraph starts on the previous page, 04-35. It's paragraph 75.2. This is in the context of discussing truth and public interest defense. Then one goes over the page at 04-36 towards the top of the page. Given the applicant's prominent role in political society and his position as a parliamentarian, the naming of him by the complainant as the alleged perpetrators in the public interest and benefit, The applicant went to great length in his founding affidavit to explain what a well-known public figure he is. The public have an interest in knowing if a prominent political figure has been accused of rape, irrespective of whether or not it is an alleged case of mistaken identity. The public have an interest in knowing if a prominent political figure has been accused of rape, irrespective of the police confirming that he is not a suspect. The fact remains that a prominent political figure was named as a suspect by an alleged victim of rape. This is in the public interest. Also, given the applicant's status and position of a public office bearer, he is subject to greater scrutiny than an average citizen. That's the point, my lord.
That's their case. That's their case
but-
in the second and third.
But that's the point. Look at what they carve out. They say, irrespective of the countervailing facts, it's his identity alone which justifies the public interest. And all the authorities are to the opposite point. The public interest, the public identity of the defamed is not the end of the inquiry.
Right, yeah, that's the point. So the authorities seem to me to suggest that there's no sharp distinction between public figure and private figure.
Correct.
That the public figures still have well, no matter how public the figure, it isn't always a matter of public interest to report everything about them.
Correct.
That's the issue. in this
Correct.
case. So I can subject to what Mr. Caron says, I can accept your submission if it is that 75.2 of the answering affidavit is an over-strong statement of what the law actually says about public benefit reporting and public figures. But it kind of begs the question, doesn't it? On these facts, in these circumstances, was the report, were the things reported in NOM 1 on the one hand, and NOM 2 and 3 on the other, was it in the public interest to report them in that way at that time? And so, subject to what Mr. Caron says, I don't really put too much store on that that set of allegations. What I would like is some sense from the applicant what the features of this case are that demonstrate that it wasn't in the public interest to report these allegations in the way that they were reported in NOM 2 and 3. I think we've covered NOM 1.
Yes.
And I'll hear what Mr. Caron has to say about that. But in NOM 2 and 3, you say, first of all, the manner of the reporting was such that an entirely different slant would have been placed on the article had the journalists done what they were supposed to do in your submission.
Mhm.
That's wait for the police and go and look at the CCTV footage. Had they done so, they would have published an article that wasn't defamatory.
And we wouldn't be here.
You wouldn't be here. Their failure to do so means what they did was unlawfully defamatory.
Yes.
What else in this case bears on public benefit and public interest?
Well, I just want to point out in respect of this, and if your lordship can have the annexure I just pointed out to you, which
Yeah.
was at 01, starting at 01-112. And one must compare what the answers are given and then what appears in the article. Because the Daily Sun has no difficulty in repeating some of these statements, but it leaves out critical ones, which would add, we would say, further complexion to the way in which this article is reported. And here's an example. Towards the bottom of 01-112, your lordship will see that there's and I'm deliberately not reading all of this into the record.
Yeah.
The venue is identified, the date is identified, and a question is put: do you confirm or deny if you were at said place on said time?
Yeah.
Over the page, and I think it carries on. You can see at the top it's cut off on the date and time. I think that's how the screenshot works. There's the response here. I have never been to that location and place in my entire life. Here's the second response. the CCTV cameras can and should be helpful in this case. So never mind the issue of mistaken identity. What the applicant is saying is that there is direct evidence that exists, which contradicts every one of these questions that you are putting to me. And if one goes and reads the article, there's not a single mention of that kind of information that was volunteered by Dr. Ndlozi. Not a single mention of the CCTV footage. And why is there no mention of the CCTV footage? Because your lordship will know, in providing the analysis about the word and the use of the word on the caption on page 01-7, one page back, the word ayeye is used, and in the founding affidavit an explanation is advanced. So it's almost as though the attitude taken is that, well, we can say this, we can sort of make good on our duty to represent what you're saying, but at the same time there's a wink that's given that actually there's some doubt that there exists here, or there's some reason for you to further question what it is that you've said in rebuttal. And the absence of the directly contradictory evidence, which was volunteered by the complainant, is omitted, then your lordship must understand that the implied meaning of the article is that these explanations given by Dr. Ndlozi are no good. And we say that in and of itself is the further sting to the article. My lord, despite my best intentions of addressing different discrete topics with you, I think that we've spent most of the morning going through all of them.
It's been very helpful the way we've done it, but if you have anything else,
I'm indebted.
Deal with. There is the issue of the what the respondents say about the procedure.
Yes. With respect, I'm not sure whether my learned friend's opposition to the procedure is one in principle or one, so in other words, no defamation proceedings can ever be brought by means of application, or whether it's a complaint that pertains to remedy.
Well, there are two options. We can get into it now, or you can wait to see what Mr. Keranos says and you can deal with this in reply. Just perhaps you want to respond to the question I have. In EFF versus manual, there's a long discussion of the procedure adopted there. And in the end, given what they said were the exceptional features of the case, Justices Wallace and Navsa for the whole court say you should generally, where you claim damages for defamation, proceed by way of action.
Correct.
But in that case, there was no procedural objection taken, and there would need to be a procedural objection taken if the material was otherwise, in principle, be capable of being disposed of an application. I had some trouble parsing that, but what I think was meant was, if there is a material dispute of fact,
Yes.
then you can't decide whether or not there was defamation on papers. And if there isn't a material dispute of fact,
Then you can.
Then you can.
Correct. And
and so when the in manual they say they talk about the absence of a procedural objection, what they were really saying was not just the absence of any objection, the absence of a good one based on ordinary principles.
correct. And may I just add one further rider to your lordship's summation of manual, is that the difficulty that the applicant in manual faced is that they claimed an apology and a retraction and salatium damages as one prayer, and the fundamental principle as to why Justice Matojane, sitting in this court as he was then, was incorrect, is because Justice Matojane found that an apology must be given and found that the damages must be awarded at the maximum cap without engaging in the debate about how do those two different species of relief, but claimed together, influence each other. So in other words, if you gave an apology and your apology was fairly contrite, do your damages go from 500,000 to 400,000? And what we're saying is that had we done the same thing in these proceedings, then our learned friend's objection would be correct. What's different in this case on the facts is that the apology and the retraction are pleaded separately as relief, freestanding, And then the issue of salatium is left open to the court, and if the court can't quantify, then we actively and out front say refer the matter to oral evidence. So insofar as remedy is concerned, their objection is bad.
Also, if I
With
was
respect.
to find that any one of three statements or any two of three statements were objectionable, that might affect whether I could calculate an appropriate remedy.
Correct. Correct, because that would require you to do some sort of arbitrary exercise. Well, each one then divide by 3 is 40,000 rand or whatever the case might be.
My division is even that.
Well, at least one of us might eke home on that score, my lord.
Mr. Premier, it's now tea time.
Yes.
Perhaps you can chat to Mr. Karanos during the tea break. I don't know how much longer you want to take. Do you want a little bit of time after tea, or are you going to rest just before tea?
No, I was going to say one thing and sit down there.
Very well, let's do that.
The only thing I was going to say is that then, in respect of remedy, then our learned friend's objection is bad. And then in respect of the actual procedure that is utilized, our learned friend's objection is bad for 2 interrelated reasons. The first one is that defamation interdicts on paper, in this division in particular, are now a common mechanism that is utilized, because that's the first reason. So there's no objection in principle to the mechanism chosen. And the second one is the one that your lordship has already identified. There might be some disputes of fact, I can't run away from that, regarding, for example, the timing of when the police statement may have been known or not been known. I can't run away from that. But then your lordship has to evaluate that dispute on the ordinary principles, and none of those speak to the legal issues in front of you, which is about the unlawfulness of the defamation.
I suppose the question is then, are you content to have this matter decided on the respondent's factual version?
I'll have to take an instruction for that over tea and come back to you, my lord.
Thank you.
As the court pleases.
Mr. Karanos, but for Mr. Premier's instruction, I think that we'll be ready to start with you after tea.
Please, my lord.
Thank you. Court will adjourn.
instruction?
Yes, my lord. The instruction is we can.
You're content to have the matter determined on the factual version in the respondent's answering?
Correct. Whilst I'm dealing with facts and with my learned friend's indulgence, the Rule 35 issue, as far as I'm aware, was about to become fully blown between the parties, but was ultimately abandoned in light of securing a hearing date, because there is some history about the hearing date at this matter.
Was there an application?
No, there wasn't. It didn't reach that stage.
Right.
By that stage, I think the parties continued with it.
Did the respondents give any reason for not producing the statement?
As far as I'm aware, that is not the case. Not that we can find, but I will defer to Mr. Kyrinos in case he has a more pertinent answer.
Thank you, Mr. Premier. Mr. Kerry.
Please, Your Lordship. Well, it's where to begin. So many different issues in this matter. But let me begin by saying this. I was intrigued to hear my learned friend suggesting that the case is not that the Daily Sun reported that Mr. Ndlozi had as a fact raped the complainant, because their affidavits and their heads of argument, and I may say it's almost as if they filed two sets of heads of argument, because their replying affidavit really just replete with legal argument. But therein, they also doubled down and made the suggestion that what the Daily Sun was guilty of was saying that Dr. Ndlozi had raped the complainant. So we came to court today expecting the argument to be that what you reported and what you insinuated, at least in the article, is that Dr. Ndlozi had in fact raped the complainant. I'm now here today, but no, that's not really what they're saying. They're accepting that we did not report that Dr. Ndlozi had raped the complainant, but rather that we reported that the complainant had given a statement to the police in which she alleged that Dr. Ndlozi, or a person whom she identified as Dr. Ndlozi, and who identified himself to her as Quinton, which she obviously incorrectly spelled in the police statement, had raped, or she suspected he'd raped. Remember, she said she'd fallen asleep and so forth. So it's a slightly different ballgame that we're in now, because it appears that the Daily Sun no longer has to meet a case that we alleged that Dr. Ndlozi had raped this complainant.
Well, if one reads the papers sensibly, Mr. Kerrinos, and I understand that there are, I understand what you're referring to in the various papers that you reference. If one reads the papers sensibly, the case setup seems to be that the report of a complaint of this nature in itself lowers the applicant in the estimation of right-thinking members of the community. It's prima facie damage. Can of course be saved. Either you inaccurately, either the Daily Sun inaccurately reported that there was a police complaint, in which case the question is reasonable provocation.
Yes.
But nobody suggests that that was inaccurate.
Well, not anymore.
I suggest on a constructive reading of the papers, nobody suggests that that's inaccurate. So the question is really about truth and public benefit. And as you point out in your heads of argument, demonstrates to me that perhaps, Mr. Kerrinos, you're a bit more perceptive than you've made out. As you suggest in your heads of argument, the real question is whether it was in public interest to report news of this complaint in the manner that it was done.
Yes.
And that seems to me to be virtually the only issue in this case, depending on how one constructs the billboard and the context in which it was displayed.
Yes.
So it seems to me that the issues, subject to what you want to say, Mr. Kerrinos, it seems to me that the issues are actually quite narrow.
Indeed.
But I accept the degree of constructive interpretation is required to get there.
Yes. Yeah. And unfortunately, it appears that there's a lot of time wasted in the various affidavits and in the heads of argument, certainly by the Daily Sun, trying to explain that we didn't say that Dr. Ndlozi raped the complainant. What we said was the complainant had made such allegations. That appears now to be accepted. So, as your Lordship correctly points out, that means that we, the Daily Sun, has established the truth. Not the truth of whether this complainant was raped, not the truth of whether she was raped by Dr. Ndlozi or somebody else, as he alleges a case of mistaken identity. That's not the issue. We established the truth of the fact that we had published a story saying that she had laid a charge, or she had given a statement to the police making that allegation, and that is undoubtedly true. The next question, as your Lordship correctly then points out, is okay, if that is the case, was it in the public interest to have...
Can I take you to NOM1 first?
Yes.
Because the question in relation to the first statement is a little bit different. I'll start out with the question I asked Mr. Premier. Can I accept on these papers that respondents never had possession of the police statement itself?
My Lord, I'm not going to give an emphatic answer on that because it doesn't appear to be clear from the paper.
So what we have in the answering affidavit, the respondent's version is in paragraph 27 of your answering affidavit, baseline 04-13. And how the complaint came to your journalist's attention seems to be set out there.
Yes.
And it doesn't say anything about having possession of the statement.
Yes, it doesn't.
And it's common cause that you didn't, the Daily Sun didn't speak to the complainant. So the most natural construction of these papers, in fact, I think the only reasonable one, is that someone in the police service rang up one of your journalists, one of the Daily Sun's journalists, and said, we've got something that might interest you. We can leave aside the motive that someone in the police service might have had for doing that. We've got something that might interest you. There's this complaint, and I've got it in my hand, and I'm going to read it out to you.
Correct.
That seems to be what happened, isn't it?
It must be if you read paragraph 27 with the first line of the actual story, which says, according to the police statement, which means the facts that they're setting out in the story come from the police statement itself. And if we didn't have it in our possession, it was clearly read to us over the phone or by the source.
You don't say in your answering affidavit that you had it in your possession.
No.
And when you were asked to produce it by means of the process, that the rules of court sanction, you didn't produce it. It seems to me to be fairly conclusive that the Daily Sun didn't have the statement.
Yes, my Lord. And as I understand the rules of court, if you don't have the document, but you once had it, you're supposed to say that. I've had it, I no longer have it for whatever reason.
Quite right.
And that's where one comes to the inferential reasoning that we probably did not have it. And if I understand correctly, what we did in the Rule 3512 response is direct them to the police to get access to the statement.
Well, that seems to be fairly conclusive. Yes. Can we then go to NOM1?
Billboard put up some time before the article was available, and a social media banner transmitted.
The article was available. Yes. So it purports to be a direct quote from the complaint.
Correct, my Lord.
A complainant that Daily Sun had never met, and whose statement was never in the possession of the Daily Sun.
Yes.
But misleading, wasn't it?
Well, no, because the headline is reporting what was reported to the Daily Sun, the statement said. So what
As
is
if it had come directly to the Daily Sun. That's the difficulty.
Well, sorry, I'm not following. As if what had come down from the complaint.
From the complaint.
With respect not. Because at the end of the day, the gist of the story, which the Daily Sun is trying to hook readers with, because the applicant says it himself in the affidavit, the point of these headlines on a billboard poster, what you see hanging up on the lamppost, is to encourage people to buy the newspaper or to access the online stories, to read the story, to read the newspaper. So what is this saying to someone, to the average person or the reasonable person of average intelligence is that somebody is saying that Mbuyiseni Ndlozi raped him. That's the gist of what this headline is.
Somebody told me.
Well, not necessarily. Well,
That's
because,
the question, isn't it?
well, that's the point, Lord, because if you had the statement either read to you, so it's read to you over the phone, and a source from inside the police is saying to you, I've got the statement, I'm reading you the facts. All right? This statement is saying that this complainant is saying Mbuyiseni Ndlozi raped him. That's exactly what's reported here as the headline.
Well, no, you're quoting what you were somebody telling you what the complainant had told the police. The source you quote on this billboard is the complainant himself, who you never met and whose statement you never had. That's the difficulty. I read in your heads with some interest the case law in Seadu and the House of Lords decision in Charleston about how one looks at headlines and whether one separates them from the content of the article or not. And the position seems to be that you can't, where the headline appears with the story, at a time where, certainly put up at a time where the story wasn't even available, let alone put together with the bill.
Just say, when your Lordship says, and your Lordship's repeated this also when addressing my friend, at a time when the story was not available. I'm not entirely sure about that.
Well, the banners certainly say tomorrow.
So,
The banners certainly say the social. The story on the banner will be available in tomorrow's Daily Sun. Then there is a time, the 11th of April 2021 at 21 minutes past 5. Just a reminder, was that after the online story was published?
Lord, you mustn't ignore 01-60.
Yeah. On tomorrow's front page, yes.
Tomorrow's front page, and there's the actual front page where one can even start reading according to the woman's police statement.
Yes.
That appears right there.
Do we know from these papers how these two banners would have been placed in relation to each other? They'd be separate tweets, would they not?
Yes, and it does appear, you can see it from the bottom, the tweet deck timing. On the bottom of page 01-60.
Just on the point as to time, and I don't have this off the top of my head, the 11th of April 2021 at 21 minutes past 5, would the article, independently of whether you could click straight from here to get it, would the article have been online about it?
I'll ask my attorney to check you, I'm 100% sure. Yeah.
That would be helpful.
On this one, I suppose we have to check whether the online article in fact reflects a
Yes.
timestamp.
They use the online article as annexes to their notice of motion.
Right, so it appears that the online article my attorney points out to me, if you turn to
It's the same date, definitely.
01-62 maybe.
62.
Appears to show that the online article comes on at 10:05, and it must be in the PM, because of course the reporter only got knowledge of the story on the 11th in the morning.
So 10:05 in the evening, or 10:05 in the morning.
It's 10:05 in the evening.
And there you have some 5 hours before that, the Billboard. Is that correct?
Yes, ma'am.
The banner. So this was 5 hours before the online article.
Yes.
So I must accept that anybody seeing this, whether online, could not at that point have accessed this.
They
If
can't
I look
access
at this in isolation.
Yes, they can't access a story immediately,
Yeah.
but they can access it a little bit later.
5 minutes.
And of course, the online versions are saying to whoever reads them, the full story is going to be out in the paper tomorrow. But the online story is also published anyway in that evening. So whoever's got access to the Twitter deck,
Yeah.
and Lord, forgive me, I'm not on Twitter, so I don't know how these things work.
Neither am I, Mr. Paradox. I think we both made a very wise decision.
So I don't know how these things work, but as I understand it, the Twitter feed sends you information all the time. So whoever got access to that story of just the headline, when the story is published, would have gotten access to that as well, would have been informed that the story is now out. But I still make the point, that irrespective, the same way that the courts say you can't read the headline in isolation, you must also read the story. Resubmit must also apply to the headlines that appear on newspaper billboards, advertising that there's going to be a story.
That's what I find so interesting about the cases, because they put it a little bit differently. If we turn to your heads of argument, where you set out very helpfully a number of quotes from the case, which I have to say I found extremely useful.
And a pleasure, Richard.
There's the quote on 09-36 from the Charleston case, Lord Nichols of Birkenhead, I believe it was. I don't know if you were there.
At 09-36.
Yeah. And you quote, and this is itself a quote, I think it's Sedu, isn't it?
Yes, ma'am.
Yeah. This is not to say that words in the text of an article will always be efficacious to cure a defamatory headline. It all depends on context, one element of which is the layout of the article. Those who print defamatory headlines are playing with fire. The ordinary reader might not be expected to notice curative words tucked away further down in the article. The more so if the words are on the continuation page to which a reader is directed. The standard of the ordinary reader gives a jury, which we don't have in this country, a jury adequate scope to return a verdict meeting the justice of the case. So, Idol and Sedu effectively say, well, even if the headline is in the same textual vicinity as the story, there might be a difficulty, because there might be a chance of a headline being taken out of context. Here you have a headline which prima facie suggests something misleading.
With the greatest of respect, I suppose that's where I submit the Daily Sun differs from the Lordship's view.
Well, that's why I say prima facie, because I really want submissions on this. So just park prima facie say something misleading, I accept that you're going to have a response to this. so far away from the article that even if somebody wanted to go straight to the Daily Sun and read the content of the article there and then they couldn't. That puts us beyond what has been said in the cases about defamatory headlines and their relationships to the content of the article. I think if there is authority that can help me in a case like this, I'd like it.
Well, Lord, I don't have that authority to hand, nor have I seen it, where what's being discussed is a headline separate from an article and what the effect of that is. And surely we will try to find such authority, and you can do with my learned friend, send it to you in due course if we manage to find it. But the point I wanted to make is, all right, so let's look at this headline. Let's analyse this headline. Let's analyse what could the reasonable reader of average intelligence have thought about this headline as they see it. Imagine you and I think it's the applicants who said, if you're sitting in a taxi bus driving past this headline on a road somewhere, and all you see is Mbuyiseni Ndlozi raped me, and we of course say, but what you also see is the quotation marks. If you were reading the Twitter feed and you saw Mbuyiseni Ndlozi raped me, you would also see the quotation marks, and those quotation marks are important because what the Daily Sun is clearly conveying there is that somebody is saying Mbuyiseni Ndlozi raped me. Now your Lordship says yes, but you're misleading because you are suggesting that they are saying it to you, the Daily Sun. And my submission is, Lord, why must one come to that conclusion that they said it directly to the Daily Sun? They could have said it in a statement, as happened here, that the Daily Sun saw or was read to it or whatever. It's the same effect because the complainant, the person who's unidentified here, but we clearly know it's not the Daily Sun saying this because of the quotation marks, and also Mbuyiseni Ndlozi is unlikely, or anybody is unlikely to have raped the Daily Sun. So it's clearly a reference to a human being. Somebody is saying, Mbuyiseni Ndlozi raped me. That's what...
Speaking for myself, I think the quotation marks are the high side of the point. You're publishing an article that is obviously reported speech.
It has to be.
Even if the quotation marks weren't there.
That's why I'm making the point. It's not the Daily Sun.
Nobody can read the Daily Sun.
Sorry, Lord?
Precisely because, as you say, nobody can read.
Exactly.
So it's clear the Daily Sun has spoken to someone.
It's clear to a reader, even of average intelligence, that the Daily Sun is reporting what somebody else has said. There's nothing in this suggesting that it was said directly to the Daily Sun, and nor does it have to be said directly to the Daily Sun, which is why it's good enough if the Daily Sun had, let's call it, access to a police statement in which this person said they were raped by Mbuyiseni Ndlozi. So that's why I make the point, well, it doesn't matter. The impression of that your Lordship said we're misleading the average reader is not so.
Well, isn't the correct statement Mbuyiseni Ndlozi accused of rape?
And what's the difference?
That's what you knew. You knew because somebody in the police service had told you that Mbuyiseni Ndlozi had been accused of rape.
Yes.
Mbuyiseni Ndlozi raped me implies that you have either read a statement from someone, or they have come to you directly and already told you that Mbuyiseni Ndlozi is raped.
But that's exactly my point.
Don't you see the difference between those two things?
No, with respect, I don't. It's either a person coming to us directly and saying, Mbuyiseni Ndlozi raped me. It's a statement by them of what they believe is happening. We don't know the truth of that. We weren't there. Or you've had access to the statement in which this person has said the same thing. Mbuyiseni Ndlozi raped me.
Well, you have access to a person who has read the statement to you. You don't have access to the statement. That's the difference.
But what difference does it make?
Well, the reliability of the whole thing, for a start. I mean, the directness of the speech put on Billboard puts the case far stronger than the Daily Sun was entitled to put it at that stage, didn't it?
Only if the Daily Sun had reason not to believe their source, had reason to believe that what their source was reading to them was not from the police statement, and nobody in this matter has suggested, not even the SAPS or anybody, not in Brigadier Peters' press statement, was it suggested that what we reported about the statement was incorrect. It's never been suggested by anybody. So that's why I say there's no reason for that reporter at the time to believe that what he's been told is contained in the statement is I don't want to say wrong because we don't know. I'm not talking about the factualness of the rape or not. I'm talking about what's contained.
Of the statement.
The fact of the
facts in the statement.
Yes.
Yeah.
He hasn't been told that that is not so. The fact of the statement. So that's why I say it doesn't matter whether the person came to him directly and reported exactly what they reported to the police in the statement. What's the difference? It's still a report by someone saying Mbuyiseni Ndlozi raped him, and that's what they then put on the headline.
The quotes do make a difference because who are you quoting? What are you quoting? What is the Daily Sun quoting in that movement? Can't be the statement because it doesn't have it.
Correct. So
can't be the person who made the statement because they haven't come to see the Daily Sun. The only person who could be quoted is the person who read the statement out over the telephone.
No, but they're not quoting that person because that person is not saying Mbuyiseni Ndlozi raped them. It's got to be.
That's the point. That's
got to be
misleading.
Well, no, it's an indirect quotation from what the person is suggesting in the statement. The complainant is suggesting in the statement. That's what they are quoting. If you want to call it a quote.
I'm sorry, I thought it was you who wanted to call it a quote. I started off saying I think it makes a difference. Now I wonder whether it does.
Well,
but I believe the respondent's version throughout has been, this is a quotation and that's important.
Yes, my lord. Well, quotation is perhaps strong because it's not a direct quote from the complaint. We know that. But what it is...
Does the person who sees it from the minibus taxi driving up the Anne Smarts know that?
No, they wouldn't know that.
And does that matter?
It doesn't matter. That's my point. It doesn't matter because the gist of the headline still remains that somebody has suggested that they were raped by Mbuyiseni Ndlozi. That's all it is.
Well, I suppose, does it make a difference? It implies that somebody has suggested that directly to the Daily Sun. And of course, that's not right. There's something in the extent to which an ordinary reader would be inclined to trust the Daily Sun or a news outlet, or the content of the statement, or assign weight to the content of the statement. Maybe more weight would be assigned in those circumstances than if they had have known. But what actually happened is that someone in the police force read the statement out over the phone to a Daily Sun journalist. Isn't there something about weight, authority, trustworthiness?
No,
and it's all there in the articles, right? So once you read the articles, you know what the situation is.
Yes.
But you don't when you read the billboards.
Yes, but my lord, with respect, maybe we're all falling into the trap that the case law warns us about. You're all supposed to take off your judicial robes.
Yes.
As trained lawyers, we tend to be over-analytical about everything. My wife often says to me at home, when we're having an argument, stop trying to be a lawyer. It's difficult to take off those robes, to take off the judicial robes, and see it just as an ordinary person in the street would have seen that billboard. And the point I'm trying to make is, all that the average, the reasonable person walking down that street, all that would have been in their head when they saw that headline, even with the quotation marks, even though it turns out not to be a direct quote from the complainant, or even a direct quote from the statement. The point it brings home out of it is that somebody has made the allegation, as appears there, that Mbuyiseni Ndlozi has raped her.
Yes.
Now, when you go read the story, that's exactly what has been reported by the Daily Sun, that somebody has made the allegation that Dr. Ndlozi has raped her. Full stop. The story, however, goes a little bit further than the billboard, because it then also reports Dr. Ndlozi's version very prominently in the article, and we mustn't forget that. But the point is, you're dealing with a billboard. It's supposed to have a catchy headline. It cannot have the entire story. Otherwise, you'd be doing this in small print and nobody would be able to see the billboard as they're driving past or walking past the billboard. That's the point of the matter, is they are headlines and nothing else. They're not expected to be the full story. They're not expected to convey the full story to the person who fleetingly sees the headline. The person who fleetingly sees this headline, all they know is that somebody is accusing Dr. Ndlozi of having raped him. And that's the story. And it's not defamatory for the Daily Sun to have said that even in the headline. Just as the same, it's not defamatory to have said it in the story when you read it.
Well,
because that's the fact of the matter. Somebody has accused Dr. Ndlozi of raping.
Let me put my judicial robes back on and start analysing this as we're required to. The report of an allegation of rape, especially in these cases, would tend to lower the subject of that report in the eyes of a right-thinking members of the community. And so the question is really whether the defences that are available to the respondents in this case exclude the animus behind the defamation. If it is inaccurate, if there is something misleading about a direct quote from someone we know the Daily Sun doesn't speak to in the statement that they present, then there's a falsity in the statement. And the analysis is different than it is in relation to the other two statements. The other two statements aren't false in any extension. And the question is whether there's a public interest. What I'm trying to get at is this statement might actually be false or misleading in some sense. And then the analysis is reasonable publication, not truth of publication. That's what I'm driving at. Do you see what I'm
take the point, except though, I suppose that when you're relying on truth, one's got to be careful that it doesn't have to be the exact 100% truth, as long as it's the true gist of what you say.
And that's the interpretive argument you've been advancing.
Yes, and so let's accept that this headline as it is might be slightly misleading, as your lordship suggested. Let's postulate that for argument's sake. The question is whether that incorrectness of the statement defamed because we mustn't forget it's all about defamation at the end of the day. So the way the headline was structured, and that it may have misled the reasonable reader, but did that little bit of incorrectness in the statement lead to the defamation of Dr. Ndlozi?
Was it reasonable? That's the question, isn't it?
Yes. Well, I suppose one can also argue on that basis in addition to say that, well, even if it was an untruth, which it isn't with the greatest of respect, but even if it was the Daily Sun unreasonable in reporting it as it did? Remember, it's now got access to
was it unreasonable in putting that billboard up in that context, using those words?
Yes.
Yeah.
And our submission is no, it's not. For the same reasons I've just argued. Because ultimately, what this billboard set out is really a summation of the article, the gist of the article. Somebody has accused Dr. Ndlozi of raping him. That's it. And that's what we say the article is really all about in any event. And it's the same as the billboard. So if the article is, if one finds the articles were true, I suppose that's the end of the debate, other than the public interest, which I'm going to get to. But if one goes to the alternative of reasonableness, our submission is it was reasonable to publish that story, bearing in mind what we had found out.
But there's no sense in which I can find what appeared on the billboard was a direct quote, is there?
Well, it's an indirect quote, let's put it that way. It's an indirect quote.
Do we know within the statement, the words?
Lord, I don't believe that in the actual statement.
Sorry, I'm just trying to get the billboard.
You find that at NOM1, the notes of motion, 01-6.
Mbuyiseni Ndlozi raped me. So we know that can't be a direct quote because we know that if it did appear in the statement, then those words weren't conveyed to the journalist. We know that the complainant didn't say that directly to the Daily Sun. So it is a gisting of the content of the statement in quotation. I just need to know how to interpret it.
Well, my lord, the published article begins with, according to the Lord's police statement, Mbuyiseni Ndlozi allegedly raped her in the early hours of Friday morning.
But that again is a gist. The quotation marks, ordinarily when a journalist quotes something, it's direct speech from someone else. And a reasonable reader would be entitled to say, well, in my prima facie again, in my view, somebody has gone and said those words to the Daily Sun, or the Daily Sun has seen a document in which those words are said.
Yes, well, so the word Mbuyiseni Ndlozi raped me, I can't tell you, Lordship, they were in the statement as directly as that, or they were not.
So it's a gist. It's the gist of the statement dressed up as a quotation.
No, what I'm saying is we don't know because we haven't seen the actual statement whether those words Mbuyiseni Ndlozi raped me were actually used in
To quote it, the Daily Sun would have had to have seen it.
or the source had read it over the phone to the Daily Sun.
Yes.
And they took notes of those words. I don't know.
But then you're quoting the source, not the
Yes.
Yeah.
The closest the article comes to actually saying, other than that first sentence, is where she says she woke up and remembers that Quentin was on top of her and she was naked, which then leads to the gist of, she's accusing him of rape.
This may go nowhere, Mr. Carroll. I'm just trying to
Of course.
work out what to make of NOM1. The applicant pertinently identifies particular statements and he says each on their own are a problem.
Yes.
And of course, I don't need to tell you, one has to construct them.
Yes.
What is really being said here? And what I'm putting to you is that from everything we've discussed, what is being said in NOM1 is the gist of a statement with quotation marks around it. I tend to add a bit of extra pizzazz.
Well, the quotation marks are important because ultimately, even if it turns out not to be a direct quote, I'm not 100% sure from the papers, but it's to signify to the readers out there that it's not the Daily Sun saying.
Yeah.
It's clearly somebody has made that allegation. It's an allegation by somebody. That's the true gist of what the headline's all about. And what I'm saying, Lord, is that that's not untrue that somebody was saying Dr. Ndlozi raped him. And so we submit that we get by on the truth. Although it was cast as possibly as a direct statement, it was it's still substantially true. That's the point I was trying to make earlier. It's substantially true. And then we'll discuss public interest in a moment. And if it's not substantially true, then of course we're going to discuss, I guess, on all three of the impugned statements, the not only public interest, but of course also the reasonableness of the publication.
Well, have we covered NOM1 now?
I think
I've
so.
asked you everything I need to ask you. In relation to NOM2 and 3, you can address me on the basis, provisionally, that I accept that what is reported in NOM2 and 3 is the fact of the complaint and the applicant's response to it. And that the fact of the complaint and the applicant's response to it are reported truthfully.
Correct. Save just, of course, and I think we all know this by now, but on NOM2 on page 01-8, We know that the portion police comment added was actually only added the following day by the...
Yes, but it's all true.
Yes.
And one would see on the face of the statement, you can see on the face of the article that the police comment came later on.
Correct.
And having accepted your version on classical evidence, we have to accept that you did approach the police for comment and they just didn't give it to you before you published.
Correct.
You didn't ignore the police completely.
No, in fact, the person we contacted, Mr. K, I don't know if it's a Mr. or Miss, but K Makubela, was in fact the appointed public relations officer for the police on that day. But they seem to be suggesting to us, well, no, go speak to Peters. Why must I speak to Peters? You are the PRO officer, not Brigadier Peters.
Well, the statement the police said, as I understand it, the statement the police issued, they said, you didn't even approach us, you didn't ask us.
Yes, which was, of course, factually incorrect. Now, that just
you
brings
didn't
me...
get it. You understand that you printed this without getting it from us.
Yes.
And of course, one then invites a reasonable reader to think, well, what is involved in getting a comment out of the police? They went a step further, and they said, well, you didn't even ask. And you've established on classical evidence that you did.
The thing that intrigues me is I'm not sure what exactly we were asking the police to comment on. Were they supposed to verify that there was such a statement? The point I'm making is we didn't even need to get the police's comment in any event, because what we published was true, what this person had laid. I don't know if the correct terminology is lay a charge or given a statement, but we know what the complainant did. But while I'm there, just on that little sideshow, as I call it, of whether we did go to the police or not, much is made of the fact, the third impugned statement they're complaining about, and I just deal with that before I go to the second impugned statement.
Yeah.
They're of course not complaining about the story directly referring to Dr. Ndlozi, which is at the foot of the third impugned statement. Ndlozi is not a rape suspect, course. They're quite happy with that. What they're unhappy about is the story on the side, and that's why I call it a sideshow, is we stand by...
Very trolls.
We stand by our story. Now, the first thing I want to point out, the average reader doesn't even know which story we're standing by just by reading the headline. The number of other stories on this page, the one that intrigued me personally was that we find Madiba's lookalike at the top of the page.
I haven't seen that.
Not the one about why you need to look good for sex. That didn't intrigue me more, but the Madiba lookalike did intrigue me.
Let you move on, Mr. Carroll.
Yes, please, Your Lordship. So, which of these stories are we standing by?
Yeah.
Right? The reader has to read the story to find out which story we are standing by.
Yeah.
And when you read the story, it's conclusively about this sideshow with did we get comment from the police or did we see comment or not. But what's very important, and we mustn't lose sight of this, I'm going to ask Your Lordship to read the very last paragraph of the We Stand By Our Story.
The 23-year-old, the one that starts with those words.
Yes, and you'll see it says, we hope that the police find the perpetrator. That, my lord, is not the wording of a party who's doubling down on the story that Dr. Ndlozi raped the complainant. That is someone indicating, okay, well, we hear what the police have to say. We never said in the first place that he did rape her. We reported a complainant accused him of rape. And this clearly shows that we're not doubling down. I think those are the words used by the applicants. So I just wanted to point that out.
Yes.
And of course, once you read the story on the side there, there's no defamation whatsoever of Dr. Ndlozi. Because once you accept that this is not us doubling down, and the story being referred to is not the story about Dr. Ndlozi and the complainant and whether rape occurred or not, then there can be nothing defamatory in that. And in my submission, Your Lordship can dismiss any claim that relies on the third impugned statement.
Yeah.
If we then move to the second impugned statement, and of course, my Lord, because the third impugned statement doesn't relate to Dr. Ndlozi or defame him at all. Your Lordship doesn't have to address the issue of it was in the public interest to report that or not. The second impugn statement, if your Lordship accepts that what was reported there is true, which, with the greatest of respect, Lord, I cannot understand how anybody can suggest otherwise. It is true. Everything that is said out there is true. Nobody has put papers before the court. The applicant hasn't contacted the police to get an affidavit from them to suggest that what we reported as being in the statement was in any way incorrect. There's nothing of the sort. So your Lordship can accept that. The question then becomes, as your Lordship put, well, but was it in the public interest to report that? And whilst I accept what my learned friend submitted to your Lordship, that just because someone is a public figure does not give the media carte blanche to report everything about their private life. We accept that emphatically, Lord, and we've never said anything different in our papers. However, there is certain conduct by public figures that the public does take, or again, I must remind myself that not everything that is interesting to the public is in the public interest, as the English case law has pointed out to us. But it is in the public interest to know certain things about public figures. And one of those, my Lord, is it must be important for the public, and it must be in the public interest to know whether a public figure, as one as prominent as Dr. Ndlozi is in South African politics, is this person prone to criminal behavior, or is this person prone to immoral behavior? And in this country, and especially with the drive against gender-based violence, it certainly must be in the public interest to know that a prominent politician has been accused of an egregious criminal act such as rape, particularly in the light of the fact that this is Dr. Ndlozi who has spoken out against gender-based violence in the past, probably will do so in the future, I'm sure, but also the party that he represents in Parliament has a very strong manifesto against gender-based violence. Now, if that is the case, and these facts we glean from the applicant's own affidavit, if that is the case, how can it possibly not be in the public interest to know that a person such as Dr. Ndlozi has been accused of rape? Not that he committed the rape, and that's very important, because that's not what the Daily Sun reported, but that someone has accused him of rape. They've not accused him in a conversation, in a nightclub somewhere or something like that. They've gone official, they've gone formal, they have gone to a police station and written out a statement with facts setting it out. So in those circumstances, my Lord, we submit it definitely is, and it must be in the public interest to know of that fact. Of course, at the same time, we must not forget, it is also in the public interest to know that Dr. Ndlozi has denied such allegations. I'm not going to say refuted such allegations, because that's also a very important part of this case, because the applicant seems to contend that the mere fact that Dr. Ndlozi denied the allegations and said he has an alibi is conclusive. And we submit that can never be conclusive.
A bit further than that, he said that there was a duty to investigate to a limited degree the facts that the applicant had placed before the journalist.
Yes, Lord, again,
I'd like to hear your submission.
Yes. Yeah. The story that we're reporting is that a complainant laid, again I'll say this, laid a charge. I'm going to keep on using that because that's what I understand someone does when you go and give a statement.
You can accept that I will understand it in the sense
that please, Your Lordship.
Yeah.
So she lays a charge, she gives a statement in which she alleges Dr. Ndlozi raped her. It is not for the media to go and investigate whether that allegation made is correct or not. Now I'm going to get to...
Well, doesn't it depend on the stage of the inquiry? I think it's the Madiri case you put in front of me.
I know it well.
Quotes, yes you do. And there's a quote in that decision from and a gloss placed on another decision written by Moreje.
That's the Solomon decision.
The Solomon decision. And there's a quite a wide-ranging discussion that I don't think is conclusive either way on these facts, of exactly when it can be in the public interest to report an allegation of criminal conduct and in what context. That decision certainly isn't authority for the proposition that merely by virtue of his position, even by virtue perhaps of what he and his party has said about gender-based violence, a very early stage allegation that we know was, well, the police excluded the applicant within hours if not days if not hours. How do I place those facts? The fact that the investigation was at a very early stage, the applicant was ultimately excluded by the police. How do I place those facts in the context of what was said in Madeira and in Solomon about the circumstances in which it might be in the public interest to report a complaint of criminal conduct?
Yes, Lord. We would submit that the fact that Dr. Ndlozi is such a high prominent politician in South Africa, he's not some lowly politician in one of the parties and somebody who most people have never heard of. This is somebody that's very well known, very prominent in South African politics. Most, if not all, of the public in South Africa knows who he is. That must be weighed up, that there's a quicker need to publish that story that he has been accused by someone of rape, bearing in mind the stance, not only of Dr. Ndlozi, but also of the EFF against gender-based violence. So there is an important story in that, and there's an important public interest in knowing that such a charge has been laid against Dr.
And what
Ndlozi.
to follow from your argument, there's a public interest in every complaint that's been made against him, even a frivolous one. Is there?
Well, it depends what the complaint is. This is rape, not some frivolous. This is a very serious crime.
I'm not saying anything about the quality of the complaint in this case. From the papers, it seems to me that the complaint, when it was made, was genuine. The police were able to exclude the applicant from their inquiries very, very quickly. And as the applicant said, it appears to be just a case of albeit with very, very substantial consequences.
Yes.
I don't mean frivolous as to the gravity of the charge. I mean frivolous as to the weight of the charge, the demonstrability of the charge. Is every single complaint made against this applicant, even a very, very severe conduct, even if made in bad faith, even if made frivolously, in the public interest to publish?
Well, we would submit yes, and we'll explain why I say that. It may turn out to be a frivolous complaint, ultimately. But the public has an interest in knowing of complaints, particularly that affect the public's perception of this person, in the sense that this is a person that people are voting for, that people are voting for to represent their party in Parliament and so forth. So even if there's a frivolous complaint, the public should know that this complaint has been, and when I say not just a complaint, it's more than that in this case. This is a young woman who had the bravery to go to a police station and lay a charge of rape. It's a big thing. It's a big thing also for this complainant, which everybody seems to be boring.
Let me just make myself clear. I don't say this was a frivolous complaint. I'm trying to detect the limits of your argument on public interest. So not whether or not I ultimately conclude that it was in the public interest to report this complaint in these circumstances. I want to know what you say about where the cases take place on the limits of public interest in the situation of someone like the applicant, who is, I accept, has a degree of prominence.
The problem with the cases, my lord, is that the judges seem to resort to the old line when they can't quite place limits of saying, well, it's all facts driven and circumstances driven. The facts of the public interest will differ from case to case and so
Yes.
forth.
Is that as far as it goes, is the question?
In my submission, yes.
Yeah.
Because whether something was in the public interest or not in one case might be completely different in another case based on different facts.
Then what you seem to be doing is, the submission you seem to be advancing is that the mere prominence of the applicant in this case makes the specificities of the thing actually less relevant. And that seems to be in tension with what the case is.
No. What I'm saying is you'll take all of those factors into account and approach it from a holistic basis. So, yes, there's the prominence of the I won't call Dr. Ndlozi the complainant, let's say the applicant. His prominence is a factor that must be taken into account. The severity of the charge must be taken into account. So, let me use a perhaps stupid example. If Dr. Ndlozi is reported at a restaurant somewhere to have used vulgar language against someone in the course of an argument about something, someone spilt, their Diet Coke over him and he used vulgar language. It's not in the public interest to report, oh, Dr. Ndlozi uses vulgar language when he's angry. Who cares? But when the charge being made against him, the complaint being made against him, is that he raped her, that's a whole different ballgame. And that is in the public interest to know, even at an early stage. The third thing is the detail of the statement. It wasn't just someone coming along and saying, Dr. Ndlozi raped me. No detail, so that you can try and ascertain, well, is there veracity to the story or not? Or is it just someone coming up with a nonsense allegation? This had detail. It had the place, and how the name that was given to this lady. Remember, she said that she didn't know this person. She must be one of the few people in the country who doesn't know Dr. Ndlozi. But she didn't know him, or she didn't identify him at that stage. The name Quinton was given to her. Later, she sees him, I think, on Google or something, and she then realizes, this is the person that I believe raped me that evening. And then, as I said, has the bravery to go to a police station and actually lay a charge of rape. Knowing, as we know, all the problems in South Africa with police investigating and not investigating rape charges, and not according them the attention they deserve. But, so if you take all of those factors into account, so it's the prominence, the severity of the charge, the detail of the facts, it is an important story for the Daily Sun to bring to the attention of the public, and it is in the public interest to know that someone has laid such a detailed, serious charge against a very prominent politician.
The prominence of the applicant weighed with the gravity of the charge, and the fact that the complaint for the charge, there wasn't a charge. The complaint was on its face one with a level of detail, even if read out in every fact, that you can accept as non-frivolous and having some substance.
Correct. And then, of course, we must also take into account that when you then decide, although this may be more on the reasonableness, when you then decide to report that, you also take into account that it's in the public interest to get the version of Dr. Ndlozi and to publish that prominently. So what you are bringing to the attention of the public, and it's in the public interest to know this, is that somebody has laid a charge of rape against Dr. Ndlozi. It's not a frivolous charge, and there's detail and so forth. At the same time, however, Dr. Ndlozi is saying, mistaken identity, it wasn't me, I was never there. And then let the public decide You know, but they don't. The public is not even called upon to decide. That's the point of the story. There's no comment or opinion. They're not called upon to they're not called upon by the Daily Sun to decide whether Dr. Ndlozi is correct or not.
There is a comment implied by a
Yes, I've seen that.
Spin. It's a bit of pizzazz.
Well, my little friend called it a little wink.
Yeah,
Right. But with respect, my lord, if someone lays a complaint of rape against you, even if you are ultimately innocent, you are in trouble. There's no doubt about that. Police are going to come ask questions. They're going to ask hard. Well, one would have supposed they were going to ask hard, probing questions. It just strikes me in this case as to, and of course, your lordship doesn't have to make a finding on it, and it's irrelevant as to why the police so quickly discounted him as a suspect based on his version that it wasn't him and he wasn't there. But somehow completely ignore a complainant's version that it was him and he was there. But you don't need to speculate on that. It's immaterial to this matter because the Daily Sun was not publishing a story that he did in fact rape. They were publishing a story about here's an allegation and here's the counter version, and so we'll wait and see how the story develops in due course. And my learned friend, and perhaps it's an appropriate time to bring this to your lordship's attention, my learned friend has repeatedly referred to the repetition. And we all know the law that if you repeat a defamatory statement by somebody else, you're equally guilty of the defamation. Except, however, that the media has an exception to that. And I'm going to refer you to the case of Grant versus Torstal, which is one of the cases that we've referred to in our heads of argument. I believe it was a Canadian case.
Is it in the bundle?
It is in the bundle, my lord. You will have seen that.
Give me the reference in the bundle.
Yes, my lord. It's under it's item 15 of case lines, respondents' bundle of authorities. What we did, my lord, is we only uploaded those cases referred to by us that were not already uploaded by the applicant.
Yeah.
And you'll see that item. Sorry, I just lost it now. Yes, item 25. It's in fact, if you want to go to a page number, it's 15-315. And it's a very long case because it goes up to 15-386. And the lordship will be happy to hear. I'm not going to refer you to everything in that case, but only to paragraphs 119 and 120 of that case, because
119 and 120.
Correct me, where they discuss the repetition rule and what it means. And there's a nice quote from the English case where they say the law will not protect a defendant who is willing to wound and yet afraid to strike. So the first person who makes the defamatory comment is the person who strikes, and the person who repeats is the person who wounds by repeating it. And they say, in sum, the repetition rule preserves the accountability of media and other reporting on matters of public interest. The bald retailing of libels is not in the public interest. Now, you would think this is all against me, but I'm getting to the point where it goes well for me.
Well, sorry, just before you go there, doesn't the applicant's reliance on repetition entail accepting that the applicant's case is what we now know it isn't? What you did was repeat the proposition that the applicant raped someone, as opposed to the proposition that someone complained to the police that the applicant had raped them.
Yes, but what as I understand what the applicant is saying, is that yes, you may have just merely reported that someone said they were raped by Dr. Ndlozi, but you in effect repeating the defamation that the first person made. In other words, the complainant has defamed Dr. Ndlozi by making the allegation that he raped her, and you've just repeated it by publishing the article in the manner that you did.
But do you need the repetition rule to conclude that a newspaper report that someone has broken the law in this way, that someone has had a complaint made about them, that they've broken the law in this way, will tend to lower them in the esteem of right-thinking members of the community? Will they
trying to contend is that the mere fact that we're reporting what she said is a repetition of her defamation.
It seems to me that the repetition rule would apply if you had said, as David Cummins, X accused Y of rape and we believe X and we stand by them, and this is right and this is true.
Or we've made comment on it and said it's wrong of Dr. Ndlozi to have raped his woman, something like that.
Simply referring to the complaint doesn't seem to me to be what repetition rule strikes at. Am I wrong?
No, my Lord, my submission lordship's absolutely correct. And of course I would say that because it suits me, but it is my honest belief, although those are apparently irrelevant in this court. But my submission is your lordship's 100% correct. I've been told by judges before that my opinions are irrelevant. So,
I would never say anything like that.
No, please, your lordship. But the point is, my lord, yes, that's what my learned friend's attempting to do, stretching the repetition rule too far.
Yeah.
But even if he was correct, and this does fall under the rubric of the repetition rule, what this case then goes on at paragraph 120 is to speak of an exception to the repetition rule, which is referred to as reportage. And reportage, and I must say I've never heard of this before, I've read this case, reportage really, if you consider it carefully, it really falls under the reasonableness of the publication. But really what it means is, if what the newspaper is doing is merely reporting on a dispute between two parties. Now, if you want to think of the complainant and Dr. Ndlozi as in a dispute as to whether he raped her or not, and they are merely reporting that there is this dispute.
They clearly were.
Sorry, Lord?
At some point they clearly
Yes. They were reporting that there was this dispute between the complainant and Dr. Ndlozi, and they fairly reported both sides of the dispute without entering into the arena. Then that's fair reporting or reportage as it's referred to. And that's the complete answer anyway to the repetition contention by my learned friend, even if it was repetition, which we say it wasn't. So what the story clearly indicates is the Daily Sun reporting that there is this allegation. Dr. Ndlozi is denying such allegation. He sets out why he says he's denying it. It wasn't him, misidentification and so forth. But it's not the role of the Daily Sun to be the arbiter of the truth. It's not even the job of the police to be the arbiters of the truth. As I understand it, it's ultimately the job of a court, if it ever gets there, to be the arbiter of the truth. And the arbiter of the truth based on probabilities, because the court itself will never know what actually happened. It relies on probabilities or beyond reasonable doubt test in a criminal case. So all they're doing is reporting. Here's the story. She's made this allegation, that's his version, and it concludes basically with, well, we'll see what's going on. And then they report the follow-up of what went on, which was that the police decided that he wasn't a suspect, and they're not going to investigate him any further. We reported that. So, my Lord, and I've strayed, I believe, a little from the whole public interest
well, the submissions I have are that there's the prominence of the applicant, there's the gravity of the complaint, and those both weigh in favour of the publication of a true report.
Yes.
Is there anything else?
My Lord, we mustn't also forget that we are dealing with a media respondent.
Yeah.
And so there is also the need for the newspaper and the publisher and so forth to get the first story out the door and beat other newspapers to a story. We all know and accept that is how newspapers work. It's ultimately all about readership. So when your Lordship asked, well, and you also pointed to the tests set out in a number of cases, including bogoshi. So is it a balanced report? The circumstance of how it came about? Did it need to be reported at that time?
Am I incorrect in drawing the line between this case and those cases? Because those cases apply to reports that aren't true. The bogoshi, the reasonable publication defense, bogoshi and what came after, all about cases where journalists have rushed out reports that turned out not to be true.
Yes.
And then the question is, well, they may have been false, but were they reasonably published? And then you embark upon an examination of those factors.
Yes.
That is not this case, is it?
Well, so for the first...
Are the boundaries safe for that?
Yes.
Yeah. But we left that behind. But I accept that if I were to find a degree of falsity or substantial falsity in the first statement, then we go into reasonable publication. If you want to address me on that, I'm very happy to...
Well, let me just add the rider to what your Lordship set out, as I set out earlier. A reasonable falsity in the publication which made it prima facie defamatory of Dr. Ndlozi on its own. In the sense that, so it may not have looked like it may have come across as a direct quote, but so what if it wasn't a direct quote? The gist is still true.
Yes, I mean that goes to whether it's substantially true or substantially untrue. You've accepted that it's presented as a direct quote. It wasn't a direct quote in the sense that we discussed, and you said that was incorrect. Because the substantial truth is that somebody somewhere said it. That's enough. So if I were to accept that's the substantial truth, if I were to accept that submission, then we'd be on to public interest. If I was to reject that submission and say, well, actually what you published was a falsity because it was misleading in the sense that you suggested, and I keep saying you,
I know.
you suggested that somebody had told you this, you directly quoted, then that renders the statement substantially false and unreasonable publication. Am I drawing too bright a line between the two defences, or is that in your submission how they work?
No, I think it's fair the line your Lordship is drawing between the two defences, because obviously you have to draw that line. You don't even start dealing with the reasonableness of the publication unless you've discounted truth and or public interest on the first leg. Although when one reads the cases, it appears to me at least that there seems to be a little bit of a blurring sometimes between the two concepts, which makes our life a little bit more difficult.
But if you look at the genesis of the defence, Justice O'Regan's judgment, she very crisply says, this is about when journalists can publish things that turn out not to be true.
Correct.
That's a gist, not a direct quotation. Which perhaps in this case is appropriate for me to point out.
Yes, and I don't think it was the genesis, it was the bogoshi, not the genesis, and then confirmed in Holomisa, in the Constitution.
Yes, I mean I say the genesis because that's when the Constitution finally gave us all permission.
So indeed, your Lordship's 100% correct. That is the gist. So it's all about will you still, despite it not being true or not in the public interest. Well, again, I'm not sure how public interest fits into it. So if it's not true,
public interest applies when it's true.
Yes,
reasonable publication when it's not.
So the minute that it's untrue, then one goes into the realms of whether it was reasonable to publish that nevertheless, even if untrue.
I do have one further question for you on the public interest issue. We know that in the criminal procedure there are restrictions on what can and can't be reported in rape cases where a charge has been laid that the accused has appealed. I'm thinking of section 1542B. Obviously doesn't apply here, directly, perhaps not even indirectly. But does that policy statement in that context about placing limitations on reporting in sexual offences cases tell me anything about the public interest in reporting a complaint of this nature at the stage it is reported?
Well, I haven't considered the report, to be quite honest. It has an effect or not. If I may just take a second just to give instruction on that. Yes, well, the only submission I can make quickly is that if one goes back to cases such as Modiri and Sullivan, now I know those weren't rape cases, but there are other provisions also in the Criminal Procedure Act, irrespective of rape cases, when you can and can't report a person's identity. And the courts didn't really deal with that. They still, when considering the public interest, it didn't appear to me in those cases they really considered the fact that the Criminal Procedure Act says you may or may not, in certain circumstances, report a person's name. So I'm not sure that it would make a difference to the issue of the public interest, because you see,
isn't the answer you apply Solomon and Modiri and you see what happens?
But also by the facts of the particular case. Now,
to the facts of the case.
Yes. Yeah. So what's interesting in this matter is that you have a complainant who has gone and laid a complaint. She's named the person, she's identified them that she believes raped them. She's given all the details. We don't know what steps the police took to investigate. I would imagine if they had done their job properly, they would have gone and gotten a statement from Dr. Ndlozi. They would have, in that statement, have seen, well, he says he wasn't there, and he's got 2 witnesses who can confirm his alibi. The question is whether that doesn't conclusively mean, however, that what the complainant has said is wrong, factually. We don't know that. The police can't know that. Right? So the question then becomes, does it matter that he's been charged or hasn't been charged, or does it matter that the police have decided not to pursue him any further as a suspect? The fact remains that the complainant has still said he did rape me and it was him, and she's identified him.
I just wonder whether the Criminal Procedure Act tells me anything about what public policy and public interest are, whether there's a value to be placed in the inquiry that I conduct under Modiri and Sullivan on keeping subjects of complaints of this nature confidential at this stage.
Yes,
but whether we're even beyond considering that. I'm just wondering how it all fits together.
No, I can't really help you. I haven't considered that. But I must say this, that occurs to me. I think the public policy behind not reporting the details of people in the rape case, even so it appears to be even sometimes during the entire rape trial, the accused may not be named, is more to protect the victim. So that you can't identify the victim from knowing who the accused is. In this case, what difference does it make?
You say the rationale is fundamentally different, can't be applied in this context.
Correct.
In other words.
Yes.
Thank you. Do you have anything else for?
Lord, quickly.
Yeah.
The argument about whether the correct procedure was followed.
Yes.
In this case, I know we've gone into the merits, and
well, you say I should dismiss it on the basis that they should have anticipated a material dispute of fact.
There's that, but that's just on the normal rules.
Well, Mr. Premett now accepts your version. So on facts.
Yes.
And so is there a dispute? There is just what the respondents say. That's the factual substratum of the case.
So in my submission, there's no dispute of fact which is material to the outcome of the merits of this case.
Yeah.
On whether there was defamation or not, and whether the truth and public interest comes in, all of those things. Yet, despite that, my reading of Economic Freedom Fighters and Others versus Manual appears to differ quite substantially, not only from my learned friends' understanding of it, but possibly also from your Lordship's understanding of the case, because I did not read EFF versus Manual to be restricted to only when there's a dispute of fact. My reading of EFF versus Manual is that the SCA was saying you shouldn't come for defamation proceedings, particularly where you seek apologies, retractions, and or a damages claim, a Salato claim. You shouldn't come on motion at all. And there's a long discussion in the case, and I'll take you to it in a second.
The length of the discussion might have obscured the point of it.
Well, that's
the difficulty is that the decision in Manual says this judgment must not be read to approve of the practice of coming to court for a declarator and then having your damages held over under Rule 6.5 or whatever. And then the decision says, but in this case there was no objection, so that's fine. And that just struck me as a bit odd. If it's wrong in principle, it's wrong in principle.
Correct. In my submission, once again, what the SCA appears to have done is it just have said, well, look, you've all come so far, you're sitting now in the Supreme Court of Appeal. There's no point in dismissing and telling you to go back and go over an action. It's probably cheaper to just send you back.
And if I did that,
evidence.
So what would be the value of sending everybody back to start an action here?
Well,
I know we're not in Bloemfontein, but we are a long way away from Kansas.
That is so, but we're also a long way from Bloemfontein, we're a long way from the SCA.
Yeah.
So we're not at the stage where the parties had reached in that matter. But it is very difficult to understand how they rail against using motion proceedings for a defamation claim, and then at the end say, okay, well, just go sort out your damages in oral evidence court. But that's
to be fair to the Supreme Court of Appeal, I believe I'm required to be. What they do say is there was no procedural objection, but raised by the respondent. And in this case, of course, there is a procedural objection. But it can't. But if I'm to follow that line of reasoning, it can't be any procedural objection. It has to be a good one. And then I collapse back in to, well, what procedural objection could you have to deciding whether or not something's unlawfully defamatory on affidavit? It has to be whether or not the facts are disputed.
Yeah, but the procedural objection, which they're talking about, if there wasn't a procedural objection, is that nobody raised the point in the proceedings of quote before Judge John that you can't come by way of motion. Yeah. It wasn't about this factual disputes and you should have foreseen them and so forth. And then they set out and they say quite clearly, if I read the entire case, that you must not use motion proceedings for defamation claims. And so the procedural objection they're talking about is not a specific procedural objection about a material dispute of fact.
It's rather more passive than that. We're not approving. It's something different.
Well, I think it's a little bit further than that.
Can you just take me to the paragraphs?
Yes,
I think this is important.
I think the important paragraphs start at paragraph 92, where they say, secondly, as
let me just get to the case. Yes, paragraph 92.
It is necessary to consider the proper process for prosecuting such claims. An unliquidated claim for damages must be pursued by institution of an action. No less so when an aggrieved victim of a defamatory statement seeks compensation. Now that, to me, appears pretty clear what they're saying.
But this isn't only an unliquidated claim for damages. That's the difficulty. This is a claim for a declarator and an order to take down.
But when you read furthermore, you will see that that's where my little friend, where he says, well, in this case we haven't lumped them all into one prayer and we split it up into A, B, and C. And I'm saying, well, that's not a distinction really. You're still seeking. Because what they're saying is, when you read further, is that the same issues are going to have to be determined for the purposes of whether you're entitled to damages and whether you're entitled to apology and retraction. And they shouldn't be heard separately or dealt with separately.
But then they solve the problem by saying, you have your interdict, it was defamations, and your apology, your retraction, and your damages have to be determined at a later stage. And then they say, we're doing that now, but we're not approving of anybody ever doing that. That's the gist of it. So I just wonder whether that means, that translates into a straightforward corresponding elimination. That I must send you all back to start an action.
But isn't what the applicant has done precisely what the Supreme Court has said you shouldn't do?
Decline to.
You're not allowed to do.
Well, what they say, what the applicants say is determine the interdict. Determine the order to take down, determine the declarator. If you're satisfied, determine the damages and the apology as well, or refer those to oral evidence. It's that hybrid procedure that the SCA ends up and then not so much says don't do it again, as we won't approve of you if it's done again. We don't approve of the practice. It doesn't seem to me to be a.
I'm not sure what the difference is. If the SCA is using softer language to say we don't approve of the practice, what is it other than saying you mustn't do it?
Let me just have a look.
And Marauder, about the interdict, that's the only part where they say yes, for interdictory relief, particularly urgent interdictory relief, you can come by way of motion.
I think the point is they don't express themselves clearly on what happens when you're seeking both. Let's have a look. In the notice of motion, paragraph 2 wants declaratory. Paragraph 3 wants paragraph 3.1 is a mandatory interdict, is it not? It's a do something rather than don't do something interdict.
Yes. Well, it would be a mandatory interdict.
Yeah. So you've got the SCA manual saying, well, it's okay to have 3.1 by motion. You don't get 3.1 unless you get 2. And they say, well, you shouldn't have 3.2, 3.3, 3.4, or 4 on motion because it's 2, because you can't have 4 on motion and 3.2, 3.3, and 3.4 are so connected to 4 that you can't have that either. And we know that there's been a hybrid procedure in this case, and we're not approving of it. But I don't know that if you read all of those paragraphs together, I struggle to understand what the bite is. Directly, what if you go to court and you seek an interdict, and you accept that you also seek damages, but you accept that those might not be credible on motion?
That makes submissions as to the distinction between interdictory relief and seeking apology and compensation. Their entire discussion, if one reads from paragraph 92 almost to paragraph 130, is to explain why it's undesirable and should not be done to seek compensation and an apology not in an action proceeding. Interdictory relief is different, because you're not going to be applying your mind to the necessary evidence relating to the compensation, the quantum of the compensation, and how the apology might affect that quantum. Interdictory relief is merely saying, stop doing what you're doing. That's all it is at that point in time. The court's not going to have to inquire into issues of compensation, the proper quantification, and how the apology is going to affect that quantification.
But then what's stopping me, if let's say I'm completely with the applicant on everything, what's stopping me from granting on these papers, paragraphs 2 and 3.1? What in principle is wrong with that, other than the fact that the SCA said it's undesirable? They haven't actually said you can never ever do it.
Well, what's undesirable is also the save for interdictory relief, the once and for all rule, that you shouldn't be bringing these matters. And so, stop. By the way, if you're not ready to, why you
and I grant, assume
of course,
we've had a lengthy discussion about all the reasons to be with the applicant and not to be with the applicant. But assuming I'm minded to grant the interdictory and the declaratory relief, I grant those, and I don't refer, I dismiss. isn't that the right way to
I
pass?
suppose one could do that,
Yeah.
if you were sympathetic to the applicant's plight, but of course we still submit. The court should show its displeasure with the fact that they've ignored what the SCA has said, and you shouldn't have the respondents now involved in two hearings, one just for declaratory relief and removal, and then. But I suppose if one sees the declaratory relief and the removal as an interdict in a sense, then I suppose that yes, I must concede they could have done that.
Yeah, well, that's the difficulty. I mean, if I can properly decide on these papers that there was defamation or there wasn't defamation, or the extent to which there was defamation, why should I send everybody back to rerun at trial simply because there's a prayer for an apology and some money? I don't think any. I don't know. I just don't think anybody in this room would thank me. It just seems to be not in anybody's interests. Let's take the opposite assumption. Let's assume I'm completely with respondents. Your clients could walk away from here with a total dismissal on the merits, not on a procedural ground. And surely that's preferable. Well, assuming you're right about everything, surely that's preferable to having to go through the action procedure.
No, indeed so, which is why before this matter I was actually saying that the respondents are in a little bit of an invidious position, because if we really believe strongly on our merits, we would like it get dismissed on its merits, and we don't, save for any possible appeals. But we don't. By taking the point and objecting to the procedure, which we must do because we're following what the SCA has said is a wrong procedure and we shouldn't do it, we might end up in the position that your Lordship is pointing out, that we then still involved possibly in a trial later. So that's the invidious position the respondent is in.
It seems to me there are three murky areas in this case, or at least three. The first is the procedure. Not clear to me with respect to everything you said.
Well, can I just point out before I forget, NBC versus Akanji or something like that.
Yes, I saw that.
And perhaps it would be useful to go look at what the SCA there said as well, because they might have clarified.
So you could never bring a declarator by motion. Let's say all they wanted was a declarator.
Well, I suppose you could with a declarator, because it's going to be the same test for the interdict, ultimately. I think the problem is when you're seeking compensation and a retraction and an apology. There's an effect on compensation. The real difficulty is that there might about why you always need evidence for the purposes of the court establishing the true quantification and so forth, and how
there doesn't seem to be any substantive reason why the hybrid procedure that's been adopted here and was adopted before the SCA is in principle wrong. It's just the bifurcating the proceeding into an application on the merits and an oral hearing on the damages. I have to say, I look at all of this and I think, well, what is wrong with that? If the SCA says, well, you can just never do it, I don't even have to ask that question. Let's just assume I can't interpret the SCA decision that way. What is wrong with the High Court procedure?
The procedure. That may be so, but on the facts. Now, of course, the entire determination of quantum and so forth may be more than just facts. There's also a whole lot of law, and I understand what your lordship saying that, well, when you read the law, what the SCA said, and I'm not saying necessarily I agree with the SCA, but it's not for me to agree or not. That's what the SCA has found. They've set out reasons in the judgment why it's undesirable to ever run a defamation claim in which compensation and apologies and or even just compensation full stop, even if you don't have an apology, it's undesirable to run it in motion proceedings. This court, the motion court, is not geared for those types of hearings. I think they use hearings to
my difficulty is, I think we flogged this particular horse to death,
yes.
but there's a difference between saying something's undesirable and laying down a rule of law that you cannot do it. I agree with you. If the SCA had done that, and perhaps on a mature reflection of these precedents, that's the conclusion I'll come to, then it doesn't matter what I think. The highest that it seems to be put is that it's undesirable.
I'm not sure that even undesirable is as strong as the SCA has put it, because what other meaning can there be to these rules? An unliquidated claim for damages must be pursued by an institution of an action.
Yeah.
No less so when an aggrieved victim of a defamatory statement seeks compensation. So now they're directly applicable to defamation proceedings.
I have the point.
Please, you
Just like to tease it out. Is there anything else?
Well, can I just check from the instruction to... Lord, you will of course have noted in our heads of argument that we have set out in more detail the public interest argument and the reasonableness argument. I don't want to have to repeat.
Your oral submissions on those points have been extremely useful.
No, please, Your Lordship. I think that's it, my Lord. If Your Lordship is with us, of course we seek a dismissal with the costs all over. And of course we see that the attorneys for EFF in EFF versus Manual were the same attorneys that are the attorneys for the applicant here. So if Your Lordship finds that they shouldn't have brought this proceeding by way of motion, they can't rely on ignorance. They knew, they were in the EFF case. They should have known better, is really what I'm saying. But we seek the order as prayed for in the notice of motion in relation to costs. Well, I'm not going to seek the costs of two counsel. I have to place on record that Ms. Martha is appropriate to seek the costs of two counsel.
Thank you. Thank you for your assistance.
My Lord, if I didn't exit at that time, not only would his clients reduce as well, and no disrespect was meant.
I understand perfectly.
Thank you very much, my lord. From the repetition rule that my learned friend is started to contend for in his oral submissions that is not supported by the case law. The first case I want to give reference to is in the bundle of authorities. It's the matter of Tsedu and others versus Lekota and another, 2009, volume 4, SA 372 in the Supreme Court of Appeal. And in particular, I want to draw the court's attention to paragraph 5 of that judgment, which the court can find at 13-311. Paragraph 5. And this is what I think is important to explicate. Learned friends to benefit from that defense in the way that it's been contended between ourselves and the court, they actually have to embrace the statement that they published. And they can't simply say, oh, we repeated the statement, oh, it's true, there it is, we've pasted it for you. They must actually do what they would have done had they been the originator of the defamation themselves.
Don't you get there just by finding that a report with a statement has been made as itself defamation?
Potentially, obviously, depending on the facts and circumstances, and we say that in this particular
case, you could get that.
Exactly. So that's point 1 under the repetition rule. May I just refer to point 2 of the repetition rule, which is in the context of borrowing from my learned friend's authorities. There are 4 different authorities which my learned friend's clients rely on, which I say are directly opposed to him. If your lordship will turn up 15-367, it's the paragraph 120 from that very long judgment that my learned friend referred you to.
Yeah.
If you look at what it says this. If a dispute is itself a matter of public interest and the allegations are fairly reported, the publisher should incur no liability, even if some of the statements may be defamatory and untrue. So far, so good for my learned friend. But here's the critical qualifier which my learned friend didn't address to you when he was on his feet. Provided that...
Sorry, we're looking at paragraph 120.
120, 15-367.
Yeah.
I'm reading from provided that. Because Because up until the comma, before provided, my learned friend is home and away on the repetition rule.
Numberless. Yeah.
But when he says provided, it says 1. The report attributes the statement to a person preferably identified, thereby avoiding total unaccountability. What we've learned now from the statement itself, where they say that the victim was not available for comment, from the statement which they are equivocal about whether they had it in their possession or didn't have it in their possession, is actually it was a third party who phoned them. It was the police source who phoned them and allegedly read the statement on the telephone. So even if my learned friend were correct that the exception applies, his clients don't even get out of point 1, because at nowhere in NOM2 is there mention that the leak came directly from a police source. We only learn about that after the fact in the affidavit. So at the time that the article was published, my learned friend's client falls down at point 1. What does point 2 say? The report indicates expressly or implicitly that its truth has not been verified. Well, my lord, with the greatest of respect, we know that that's not the case, because critical elements of Dr. Ndlozi's version, which contradicts the statement in the victim statement, are not addressed at all in the article. See the reference to the CCTV footage, which is conveniently omitted from the article itself. This is my learned friend's case. It's dead against him now on 2 out of the 4 requirements. What's the third requirement? The report sets out both sides of the dispute fairly. Well, we'd say the omission, the deliberate omission of a countervailing fact, which is explicitly flagged with the reporter, can never be fair. Because when the reasonable reader reads that article, they'd think to themselves, but if Dr. Ndlozi is so confident and he's saying, go check the CCTV footage, why haven't you done so? Why haven't you asked any follow-up questions? Why haven't you done your basic duty as a journalist? So point 3 is against them. And the last one, the report provides the context in which the statements were made. We'd argue again, omitting critical averments does them no favors. So with respect, my lord, under the repetition rule, on my understanding of the repetition rule in CEDU, they're unable to prove the truth, because what they've come here to say to your lordship today is we don't have to prove the truth, we simply have to hide behind the fact that the truth of the statement was given. Well, CEDU tells you the exact opposite. It's not enough to merely say that the statement was made. But let's say your lordship is against me. Let's say CEDU is of no assistance, never mind it's from the Supreme Court of Appeal. Let me rely on my learned friend's own authority. On each one of the 4 prerequisites that are required for immediate journalists to benefit from the repetition rule or to avoid liability under the repetition rule, they don't meet any one of those on their previous case. I was going to address the issue of reliability, but your lordship understood the point of reliability in circumstances where it comes from a third source that's not in the papers. I'm not going to deal with that. My lord, can I deal with NOM1 very quickly?
Yeah.
Your lordship might be familiar with the case DA versus ANC in the Constitutional Court. I apologize to my learned friends. We've only
which one?
one of the many ones, my lord. The infamous one about the text message.
Yes.
The Nkandla text message.
The Election Act.
Yes, I'm going to read out the citation because we've only found this during the break, and we haven't flagged it with our learned friends. But it's 2015, Volume 2, SA, and I am looking at pages 279 and 280 for the time being, which is the majority judgment.
Where does the report start?
The report starts, my lord, now that is a vexing question because I've dismembered it into multiple pieces. The full citation of the report is DA versus ANC 2015, Volume 2, SA 232 in the Constitutional Court. Now,
which paragraph?
I'm starting out with the majority judgment of Cameron J. as he was then, at paragraph 148.
Yes, as mentioned earlier.
Yes. Now, before I address this case, your lordship, and so as to not take anyone by surprise, your lordship knows that the dispute in this case was whether or not a text message to the effect that Jacob Zuma stole money violated the Electoral Act. And one of the main schisms between the majority and the minority written for by Justice Cameron as he was then, and the minority written for Zondo J as he was then, was about whether or not these defamation principles of statement of fact could be imported into electoral law. The majority in that case said no, they didn't. But the majority in that case, nonetheless, in paragraphs 148 and 149, endorsed the same principles we rely upon in defamation law for Utah to demonstrate that NOM1 is clearly defamatory, because it was presented as a statement of fact. And actually, in the case of NOM1, for our learned friends, why it actually gets worse is because unlike in the ANC-DA case, the DA-ANC case, the majority found that the statement about stealing the money drew authority for that particular statement from the text itself, having regard to what was being said at the time about Nkandla. The contradistinction between the conduct in DA versus ANC and NOM1 is there is no authority or qualification of what is otherwise presented as a statement of fact. Indeed, Justice Cameron goes so far at paragraph 148, if I'm not mistaken, or maybe it's 149, where he analyzes the particular poster, placard, that was complained of in Utah, and goes so far as to say that the exculpatory element of that statement was presented in a smaller text, and that could still nonetheless be defamatory because no one would pay attention to it. Well, we say, for our learned friends, the Daily Sun is in an even worse world because there's absolutely no qualification in NOM1. And my lord, the similar point is held, a similar point in the context of your understanding in defamation law was held by the minority in that same judgment at paragraphs 92, 96, and 97, Zondo J, as he was then analyzing the text. The only difference, of course, is he would have relied on the Utah principles to find violation under the Electoral Act. We say that Utah's principles are nonetheless still good for the purposes of defamation. So that's NOM1 done and dusted. May I then, I've already discussed truthfulness and how the Daily Sun fails on truthfulness. I'm not going to discuss that too much. Your Lordship has already had me on NOM3, that was the aggravating circumstances. Can I just make this point about the aggravating circumstances? And I draw the court's attention to Manuel in the SCA and what happened there. Because what happened with Manuel and the SCA is that when the countervailing facts were brought to the attention of the EFF, what the EFF did is attempted to simultaneously say, okay, well, we might have got it wrong, but at the same time we were perfectly competent to say what we needed to say because of this generic claim of public interest, because of the fact that it dealt with Edward Kisveta, SARS, potential malfeasance. But the only point that I'm making is that the SCA gave that short shrift, and the SCA said what was reasonable in the circumstances is that when the true facts were put before you, and in this case, highly disputed allegations where countermanding evidence wasn't even engaged with, your attempting to defend your original conduct is aggravating, not mitigating. And that's the only point I'd make about that. Can I come to NOM2? Because NOM2, something really interesting has happened here. Because in attempting to justify why attempting to justify why Mr. Dr. Ndlozi is fair game, there were three primary reasons in the public interest that were advanced in front of your Lordship. One was his position. Well, I've already told you, Mthembu Mahanyele says that you can be a cabinet minister, you can still sue for defamation. So his position, such as it is not conclusive. The other thing that was said, and my learned friend can correct me if I'm mistaken, is that Dr. Ndlozi is a prominent politician who himself has said things about gender-based violence, and the EFF's manifesto has a commitment about gender-based violence. And so that's why everyone should have a right to know if he's accused of rape. But then go and look at Article NOM2. Article NOM2 doesn't engage with Dr. Ndlozi and his hypocrisy, or his alleged hypocrisy, because of the allegation. The allegation is simply repeated, and no engagement is made with what my learned friend now contends in front of you on his feet. So we say that to the extent there might have been legitimate public interest in demonstrating that Dr. Ndlozi was some kind of hypocrite, my learned friend's client's articles make no factual basis for that at all, because not one word is uttered about what Dr. Ndlozi had said in the past or the EFF had said in the past. So in this instance, the mere repetition of what might otherwise be defamation can never come home on public interest, because the link on my learned friend's own version between conduct, which might otherwise not be published, and what might be in the public interest has never been pleaded by them and has never been stated by them in the article itself. So insofar as they rely on what Dr. Ndlozi had previously said and what the EFF might have previously said, the article doesn't give them any cloud cover for that, because the article doesn't mention that at all. The third reason is there was mention made about Suleiman. Can I just mention Suleiman from my learned friend's heads of argument? Because the contradistinction that we would draw with Suleiman is that in Suleiman there was a preponderance of evidence which suggested that the police were justified in taking the conduct that they did. If I'm not mistaken, my learned friends...
Well, there was a pattern of behaviour.
Correct, a pattern, exactly.
We're concerned about.
Exactly right.
That seemed to weigh the
exactly. Your Lordship has the point. The point I would make is that they've never ever attempted to plead that once ever about Dr. Ndlozi. So, to the extent that Suleiman creates a proposition that we can publish these things because it's of public importance or it's about someone in public prominence, we'd say Suleiman is the exact opposite point. So that's the issue about NOM2. My Lord, I've already addressed Maldiri and Suleiman. I apologize, I'm just working through my notes so as to not
you won't be too much longer.
repeat myself. No, my Lord, I've already made the point about running away from the facts.
Yeah.
My Lord, you know the trite authority from Cameron J, as he then was sitting in this division. I think it's from August Publishing, where just because you're a media respondent doesn't mean media exceptionalism is part of our law. We would say that notwithstanding the public